execution of the order party, there's some difficulty on my side, junior advocate part. Can it be after vacation or after?
Who appears for the petition, appellant?
Appellant, I'm for the appellant, not.
You are for the appellant.
Item 2, my lord, that is a contempt petition. I have the contempt petition.
Okay. So you want,
They want to.
you've given your consent?
Yes, it can be joint prayer.
Okay, your good name?
P. Sharma,
On request made by P. Sharma, London Standing Council, AFDC.
not.
Release the matter after?
1 week.
After a week.
I would like to mention item 11.
Yes, please.
Item 11,
Huh.
Lordship. Let it come after 4 weeks because I was supposed to file a objection. I could not. And moreover, in the meantime, DC Kamrup has submitted one affidavit by which they want to make railway the party, and I couldn't go through they have given a detailed report. I couldn't go through. So, Lordship, after 4 weeks, it can come, Lordship, and I've taken
Request
consent.
Made by Artik Majumdar, London Council for the petitioner. List after 4 weeks.
Yes, Lord.
May I please, your lordship? With the consent of the other side, my lord, I beg to mention item number 8, my lord. I am for the appellant in this matter, my lord. I have some personal difficulty today, my lord. Matter may be come up day after tomorrow or any day as per lordship's convenience, my lord.
Okay. On request made by S. Datta,
My lord.
London Council for the appellant. Not day after tomorrow, day
As
after
per
tomorrow.
lordship's convenience,
23rd,
my lord.
23rd January.
Highly obliged, highly obliged.
May it please the Lordship. With the consent of the other side, I beg to mention item number 23, Lordship. Lordship, may kindly adjourn the matter for today.
You are appearing for?
I'm for the petition.
Okay, on request made by MS
A.M. DeCosta.
DeCosta. List after?
It may be, Lordship may give any date.
You want a date?
Yes.
List on. Okay, 1st February.
Much obliged, Your Lordship.
May I please, Your Lordship?
Mm.
I beg to mention for listing a writ appeal of 2023. Basically, this is a service matter, Your Lordship. Except my school, which is Gunaipani Emi Madrasa, other schools have been provincialized, Your Lordship.
Mm.
Kindly fix it tomorrow, Your Lordship.
Why tomorrow?
Lordship, because my school is, the teachers, my school, everybody is waiting to get provincialized, Your Lordship. And this is a long pending case. Writ appeal is in 2023, and I'm not much aware of the WPC, Your Lordship.
We'll have it on 22nd.
Lordship, 15, Your Lordship, Monday.
15 is your holiday, isn't
Oh,
it?
sick. Apology, Your Lordship. Much obliged.
Item 3, 4, and 5 for admission.
Before I start, my lord, there is some few orders passed by the division bench of this honorable court, records to be produced by the government. Whether they have produced the records or not, that's very important.
Which order is it?
Initially, yes, there are a few orders. Kindly look into it, my lord. Some orders. May I tell your lordship why the court wanted the records to be produced, my lord? I just tell your lordship for what reason during the deliberation when the matter was heard by this court, why the court felt that records are necessary. Into order, some orders, few orders. Into order.
Who's supposed to produce the records? Government?
Comment.
What is it?
Very nice.
Coming from now.
It is coming from the office.
Our own building.
Okay.
Yes, there absolutely no problem. Because initially when they produced the record, that was insufficient.
Mm.
They said we want to see the entire records.
Is it the entire records as per the order of 8/6/2023?
My
It
lord,
has,
sorry, my lord, I could not, my lord, edit the record. Has come now. My lord.
I'll tell your lordship just in a very short why the court said the record is necessary in this particular matter. There is 2 writ appeals which I have filed, and my learned friend has filed 1 writ appeal against the order passed by learned single judge. So, my lord, we had a paper house, newspaper house, which was at one time it was famous, Jonasadaran. Then we could not run that newspaper house one point of time. So we have issued a closure notice. Closure notice was issued, then some conciliation took place. Then ultimately we decided to restart it. But at one point of time, we have to close down. That closure notice was sent for reference to the industrial tribunal. Now the closure notice by the tribunal, industrial tribunal said, is a valid. Closure notice, rightly it was issued. But in lieu of, the compensation will be paid to those employees under 25 FFF and 25F. That's one part of it, my lord. Now, my lord, your lordship knows the employees has to be paid the wages. Now, there is an act that's called the Working Journalists and Other Newspaper Employees Condition of Service and Miscellaneous Provision Act 1955. Initially, there was no system how the employees has to be paid. Now, this act came into force. Majetia, Justice Majetia was the main chairperson where they appointed, and how it has to be fixed. There was a committee. How the employees has to be paid, have to be paid. And accordingly, it lays down. The act lays down how it has to be placed. And it was recommended by the Supreme Court also that this was the position. My lord. Now, what has happened in this particular case, my lord? Somewhere in 2016, we didn't receive any notice. We received a notice, but they said that we have to pay to the employees amount of 1.86 lakhs, the amount. But they have not given the statement to us. So we don't know really what is the amount in head we have to pay. We came to know later on, because when the warrant of certificate was issued by the Labour Commissioner to the Bakizai, they recovered this 1.82 lakhs and warrant of arrest was issued. Once the warrant of arrest was issued, we came to know that this is 1.82 lakhs they want to realize. So we file a writ petition against this. First writ petition we have filed. And we said that is absolutely a violation of principle of natural justice. We have not received any such notice. This is what we are saying. The statement we have not received. And we took the help of 17 of the Working Journalists and Other Newspaper Employees Condition of Service Miscellaneous Act. This was the case. And there was an interim order which was passed by the court. So the affidavit was filed. My learned friend's client appeared. Affidavit was filed. When the matter was taken up by this court, in the course of hearing, then we took a point. We said that there is a provision under 17(1) where suppose the amount is due, it is not been paid to the employees. There is certain provision under 17(1) that where the application has to be filed. Application has to be filed under 17(1), I'll show, to the appropriate government. Now, appropriate government is, my lord, under the rules. That is Rule 36. 36 of the rules, there is a rule. 36 contemplates under Form C that it has to be, application has to be filed before the Secretary of the Government of Assam. That's the rule which is provided. Now, during the course of hearing, we said that how the Labour Commissioner, under what authority it has been delegated? You cannot delegate because he is not the appropriate authority under the rules. Because Labour Commission, it is Secretary of Government of Assam when the application has to be filed. So we moved this matter. The court said we want to see the records. During the first writ petition when it is pending, the records were produced and ultimately it was found by notification that delegated the power to the Labour Commissioner. We filed a second writ petition taking leave of the court. We said that how you can subdelegate it, the power delegation of power and delegated to Labour Commission. There was an interim order which was passed. Both this matter was taken up by the learned single judge. These two matters were taken up. The second writ petition, which is notification which was challenged, and we said it is not as per the rules. How can you subdelegate it? Court said, no, we will not agree with you because 17(1) said that it can be done. So on this count, the second writ petition was dismissed. The first writ petition which we filed The first writ petition, the court has come to a finding that no. What the Labour Commissioner should have been done it. Labour Commission under 17(2), if there is a dispute, because there is no notice which has been served to us. So if it is a dispute, it has to be sent under 72 before the Labour Court for adjudication of the matter, which was not done. What we do is, the learned single just said, we send it to the Labour Court for adjudication of the matter. In the meantime, you pay a sum of 25 lakhs because 1 crore 82 lakhs was the amount. You pay amount of 1 crore 25 crores, 25 lakhs, and in the meantime, it will be adjudicated by Labour Court. So we were aggrieved by that and we have come up before this court. Now, when the matter was taken up by the division bench, during the deliberation, we showed 17(1) and 17(2), how it has been done, delegation. Then the court wanted to see the records. Court wanted to see that whether their application which has been filed under 17(1) was before the appropriate government or not. The court said, we will see the records, whether it is filed under the rules. Rule says, Form C says, it has to be filed before Secretary Government of Assam. So how you have done it? The division bench, the Honorable Chief Justice, Deed and Chief Justice said, we want to see the records, what the record reveal. We said, number one, our whole case was that it is not the Labour Commissioner under the Act. And under the rules, it is the Secretary to Government of Assam, which you have not done it. Secondly, if also your contention, we agree to it, it is a Labour Commissioner, there has to be a subjective satisfaction to send it to the Labour, to the Bakizai Court, which has not been done because we have not received any notice. So he is an ex parte. This is what contention we have placed before the learned division.
Yes,
bench.
Sharma.
So this is what the division bench.
I have received that.
You're ready?
My lord, particular to my lord record, my garment may perhaps my lord.
We have to check it, my lord, because half record came. Then the court said, you please look into it. We looked into it. My learned friend looked into it. The full record was not there. Again, we don't know what is the record.
Then we'll fix a date.
Yes,
Whatever
I
you
think
do.
we should check the records, both party, because at that relevant time, where it was not the whole record was not before the court.
When do you want? When do you want?
Lordship, we have some urgency in the sense that these people are without any salary, anything else. Your Lordship. Even their arrears after closure, what they should get, that has also not been released. Therefore, Your Lordship, I will pray for a
Early date.
early date, Your Lordship. Immediately after reopening, Your Lordship.
Heard Deed House, Leonard Senior Counsel, assisted by
Teacher Robert.
Leonard Counsel for the appellants. You are appearing in which writ appeal?
Writ appeal 76 and 75.
76 of 2022. So, Mr. D.K. Sharma, Leonard Additional Senior Governor Advocate submits that he has received the records. Stop. Accordingly, list this matter on. When do you want? Give a date.
There are 25 loan. 25 loan. 26. 26. 24. 30th for a Tuesday. 30th. Tuesday. I am appearing in your lordship writ appeal number.
Mr. S. Botagul, Leonard
Writ appeal
Counsel
number
appears on behalf of
347.
the appellants in the writ appeal 347 of 2022.
Item six,
May I please, your lordship?
Hmm.
In this case, my lord, in fact, I would pray for a disposal, my lord, because there is some urgency in the matter. At the last occasion, my learned friend, my lord, took time to, my lord, obtain the latest status of the, my lord, matter. What had happened, my lord, here, the settlement of Brahmaputra Part 3 and 4
My
and
lord,
5.
before my learned pen start, my lord, some request has come from the fishery department to my lord take some time to my lord produce the status because of some my lord difficulties and internal communication between the.
No,
deputy
Mr.
commissioner.
Datta is saying that he has emergency.
Because my lord, the settlement is, my lord, otherwise, my lord, coming on to an end, my lord, on 24th of this month.
24.
Of this month, my lord, and it was curtailed by the impugned order, my lord, curtailed this, my lord, settlement. My lord. That's the reason, my lord, we are agreed. Because about, my lord, 19 cases were disposed of, but we are agreed with only one part of that, my lord. That, my lord, the settlement period, which was according to us, my lord, has to run, my lord, till 24th of January 2024. It was curtailed much earlier, my lord, and that has been upheld by this almost single judge, my lord. That's what we agreed with. My lord. That's the urgency. And in fact, on last occasion, my lord, in the month of December, my lord, 15th December, the matter came up. My learned friend took time, my lord, and quite a long time was given, my lord. I also did not object at that point of time because today is 9th of, my lord, Jan, my lord.
Difficult to have it on 24. Yeah, Sharma, when do you want?
My lord, the process, my lord, for my lord demarcation of the boundaries is, my lord, going on. That is why, my lord, the request from our government is, my lord, to adjourn the matter for at least 4 weeks, my lord.
4 weeks will be.
Well,
They are running the fishery on daily basis.
No, my lord, that's not correct, my lord, because though it was, my lord, on daily basis, we are, my lord, given the, my lord, settlement once again, my lord. But then, my lord, the possession could not be handed over. But here the issue is not with regard to demarcation, my lord. Here the issue is, my lord, whether our settlement has to continue up to, my lord, 24th of January, my lord, and whether it was curtailed my lord, beyond earlier, my lord, and whether that is justified. That's the only issue, my lord. So far as the demarcation part is concerned, my lord, that's a part of the other part, my lord, which are not concerned at this moment, my lord. And this writ appeal doesn't deal with that aspect also. My lord. We are not.
Yes,
agreed at that.
Sharma.
My lord.
We can fix a date before 24th.
I'll leave it to your lordship, my lord.
Because if you say the 24th is the last,
The 24th is the last date, my lord. Yes.
then we have to take it up before 24th.
Yes, my 10 and 18th, my lord. On reopening meeting.
No, 18 there will be some difficulty, 18 and 19.
Well, I'm allowed.
22nd.
Okay. But Datta, learner council for the appellate on request made by DK Sharma, learner additional senior government. List on 22nd.
Obliged.
My lord, can it be on 23rd, my lord, says hearing day, my lord.
Okay, 23rd.
Let me hearing day, my lord.
Item 7.
May I please?
Lordship, will I be pass out for the timing? My senior election and another court.
Lordship, may you please, Lordship. Lordship, in this matter arising out of the same judgment, Lordship, another writ appeal has been filed, Lordship, which has been fixed for hearing, Lordship. So may I pray for the, take the matter together, Lordship. Writ appeal number 332 of 22, Lordship. 332 of 22.
Likhit Hussain. When is it fixed?
Date has not been given. That is fixed for hearing, Lord.
6 for hearing well.
Lordship, date has not been given because it has been listed in the part 2 list, but this matter has not been called yet.
But no, this matter has not been admitted
Not
yet.
admitted, your lordship, and secondly, your lordship, we have also some urgency in this case also, your lordship, because your lordship, our promotion are held up because of this particular judgment. So-
Promotion has also been pending, Lordship, because of this matter also.
No, under the provisions of the office memorandum which they had put to challenge, they are not entitled to promotion. We are entitled to promotion. This is the difference between the two sets of petitioners, appellants, your lordship.
Hmm. We can hear it together then.
Lords, only a
Not
date may be
fixed date,
fixed, your lordship, that's.
Give a date.
On 25, your lordship.
55 January.
Hmm.
Yes, Lordship.
List this matter along with writ appeal number 332
Of 22, Lordship.
2022 on 25th January.
Deeply obliged, your lordship.
Item 24 from supplementary list.
It is your lordship.
Hmm.
My lord, this writ appeal is against the order of non single judge. Lordship will find the order start from page 79 is the interim order, my lord. Lordship is regarding my lord, the flat of my lord,
Hmm?
regarding a flat, residential flat, my lord, the petitioner which was holding since 2006, my lord, under the respondent. And my lord, earlier notice was issued for eviction, my lord, which was I challenged before the London single judge, my lord. My lord, my challenge was basically that, my lord, a wrong notice was issued to me, my lord, in the name of, my lord, one person, Ritupon Rekha. And my name is, my lord, Lakhi Nandi Sharma. But the London single judge, my lord,
Yes.
my lord, London single judge is also before just taking decision of this writ petition, my lord, directed to the officer in charge of police station, my lord, Dispur, my lord, for regarding, my lord, a verification, my lord. The officer in charge went to the place and found that, my lord, the petitioner's sons and another person was present there, my lord. And, my lord, at that time petitioner was also present, my lord, but the police has not reported this, my lord. I have filed affidavit also, my lord. So, my lord, but Learned Single Judge has come to the conclusion that I have suppressed some material facts, my lord, as I have there earlier there was a notice to me, my lord, and by which it was cancelled, my lord. As regard to that, my lord, I have not received any notice, my lord. And in the writ petition, my lord, that I have no knowledge about that, my lord. But, my lord, now my lord, considering this writ petition, my lord, they have also issued notice, my lord. So I have urgent of, my lord, this.
What notice?
My lord, for eviction, my lord, considering this.
Where's that notice?
My lord, I have could not able to annex, my lord. I collected it later on, my lord.
Oh. This is many things.
So I pray for a stay of this, my lord, because, my lord, she is the lady, my lord, and also not that she is defaulting.
You have to file it. When is the eviction date?
Yeah, my lord, I have filed this writ appeal is 4/1/2004, my lord. It was registered on 8/1. They have issued on 6, my lord, after filing of the writ appeal, my lord. So I have made a paragraph, my lord, prayer also, my lord, if any consequential order. They issued on 6, my lord, and pasted in my door, my lord. I have collected from there. So, my lord, so, my lord, lordship may decide the matter in meantime, my lord. This may be state matter. And this call. My lord, regarding existence of her, my lord, she was present there, my lord. Earlier, due to some illness, my lord, she was used to reside uh, with her sister, my lord. But she is now residing, my lord, on affidavit I have filed, my lord, before the London single judge. And, my lord, regarding that notice, my lord, it was issued in the name of one Rituman Rekha, who was never be examined, my lord. And not any logical conclusion of that notice, my lord. And one finding is that, my lord, in Aadhaar card and others, my name is not there. My lord, it is not possible to, my lord, issue a Aadhaar card or a, my lord, voter ID in the name of, my lord, this
Paragraph 8.
lordship.
para 8 of the judgment.
Yes, Your Lord. Yes, my lord. Regarding my lord, I have already stated before your lordship, my lord.
Allotment order was cancelled as early as 2017.
I have no knowledge, never I have received anything, my lord. No record,
How?
they have not produced, they only, my lord, in the last filed an affidavit. Filing this affidavit, they stated that my case was cancelled, my lord. Only in the last occasion, my lord. And I have filed this report in 2019, my lord, and they have filed the affidavit on 2023, my last December. And I have never received, my lord. I categorically stated, my lord. They have not shown any record also, but they have shown the notice and, my lord, the whatever the impugn that cancellation. In the cancellation, there is no name of Ritupan Dhaka, as they, my lord, served the letter notice. Only they have stated some unauthorized occupant, my lord. Nothing clear, my lord.
Who appears on the other side?
Lordship may issue notice, my lord. After issuing notice, they appear, my lord. I have checked, there is no permanent, my lord, standing council.
Urban development,
Separate standing council.
they have a separate standing. Have you served notice?
No, my lord, after, in writ petition, after issuing the notice, they appeared, my lord.
No. Standing council, urban development.
I have served, I have served one copy.
Hmm?
I have,
Have you served copy?
yes, my lord. Urban development, my lord, I have served, but regarding.
Where's the notice?
As per my clerk, my lord. I'll check, my lord.
There's no notice.
Regarding the department, my lord, earlier we have issued notice and thereafter they appeared.
Senior government. Senior government advocate has accepted notice. Hmm?
Separate standing.
They have a separate standing council.
For urban development.
I'll inform him, my lord.
Yeah, you serve copy.
Well, P9.
Okay. Heard Jiuddin Learned Council. for
I'll serve, my lord.
appellate. Stop. Register is directed to reflect the name of the standing council. Urban development in the council list and list the matter again on today's Tuesday.
Tomorrow, my lord, because they have issued notice on 6, my lord, giving
Oh.
7 days time.
Oh,
After tomorrow, my lord.
11th.
Obliged.
You serve copy of
I'll-
the learned council for the appellant shall also serve copy of the present writ appeal to the learned standing council urban development within the course of the.
Item 9 and 11 for orders. Item 9 and 25 for orders.
As far as 25 is concerned, my lord, it is impediment. So Karbi Anglong, which is Kala, my lord, he has appeared. That can be disposed of. And regarding the other part, my lord, the 9, item 9, my lord.
93 is what?
93 is implement, my lord. Implement of the Joint Secretary Revenue of the Karbi Anglong Autonomous Council, who acts as Kala, a competent authority for compensation under the Highways Act, my lord. He was originally a party in the writ appeal, so he needs to be impeached.
Okay.
So that may be allowed, my lord, because the
He is there, my lord.
Standing counsel.
Standing counsel of the Caribbean.
The implement petition is filed by Lord IA, which has already been disposed of, and re-appeal has also been disposed of. In the disposed of cases, my lord, interlocutory application is filed for implement. Whether lordship may consider that aspect. Both the re-appeal and the interlocutory application has already been disposed of by the court, my lord.
Retapably disposed. I can dispose.
I will dispose of, my lord. Take the order.
Writ appeal has been disposed.
Dispose of, my lord.
That is disposed of, my lord. That is the reason I have sought sought leave and also, my lord, clarification and or either modifying or reviewing that order, my lord. That is the connected IA, my lord, 3773. Which is item number 9, my lord. It is written in the constitution also, my lord. The IA is for, my lord, IA is for seeking leave or to modify, my lord.
What is this?
I dispose of it. No problem.
Writ appeal has been disposed of.
Yes, my lord.
Oh, where is it? Okay.
And it's been tagged with, my lord, specifically this, my lord, clarified, the writ appeal has been disposed of, my lord. I am seeking modification, alteration, or leave to, my lords, to proceed with the work.
What the learned standing, if I understand correctly, my lord, what the learned standing council is trying to impress upon is that the interlocutory application has been filed in a disposed of case.
Then how can it be? Is it maintainable?
My lord, I am seeking I am not seeking review, my lord. I am seeking modification or alteration. My lord, it's I had also a query, my lord, but registry had allowed it. There was a query, but my lords, I am not seeking review of the order. I am seeking just modification of the order, my lord. Because, my lord, there was an order passed to submit a valuation report to the arbitrator. What had happened in this case, my lords? The Assam government of Assam, my lords, had abolished the office of the arbitrator, that divisional commissioner, who acted as an arbitrator, my lords. And now they have reappointed. Order was of the writ appeal was that valuation report will be prepared and submitted to the arbitrator. And after submission, after 2 days, my lords, that there was a stay order that will be immediately automatically vacated and work will be allowed to proceed, my lords.
How can you file a modification order
Or alteration, my lords.
or alteration order in a disposed of matter?
And also either, my lord, to seek leave, my lord. I'm seeking leave also. There are 3 parts of my prayer.
In which IA?
3773. Item 9. It's clearly written, my lord. It's a dispose of writ appeal. My lord, to seek review, my lord, there has to be change in circumstances. Circumstances have not changed, my lord. It remains as if it had remained, my lords, on the date of, my lords, date of passing of the writ appeal order 28/9.
It says by suitability vacating, modifying.
Suitably, not vacating, my lord, suitably modify / alter, my lord. I'm not seeking vacation.
no. By suitability vacating, modifying order.
My lord, my copy says suit. Oh, my lord's order sheet, my lord. No, that part, my lord, that can be ignored, my lord. That vacating, I am not seeking vacation, my lord. That other part,
also,
modify.
How do we modify the order? after
Modify,
it
my
is
lords, modify since, my lord, there was a direction to conduct a valuation exercise. Valuation exercise has been conducted, my lords. It can be, my lord, since it is only about measurement and valuation, my lords. And, my lord, a substantial portion of the amount claimed, 60 lakhs has been paid to them. They are seeking, my lords, to raising of that valuation to 80 lakh. 20 lakhs is under dispute. All the grievances that, my lords, that construction has been stopped from April month, my lord. This order was passed in November. I filed this, this order was passed in September. I filed this IA in the month of December. Only, my lord, limited grievance, my lord.
Cannot be. Has to file a review.
No, my lord, to review to come in, my lord, there has to be a change of some circumstances. Circumstances are, my lord, already as the date of the passing of
Apart
the order,
from
my lord.
review also, you have other remedies. You have other remedies. You can't have an IA on a disposed matter.
I tried to point out, my lord, but it was allowed, my lord, and in fact, my lord, I have not suppressed that
Maybe
fact.
the
I've
registry
written.
might have allowed it, but the court is not allowing you to.
Because the first date, my lord, it was heard along, my lord.
When was it heard? It's coming up for the first.
No, my lord, it's coming for the third time.
This IA.
My lord, yes, my lord.
Huh. First occasion, you were directed to serve copies.
Yes, my lord.
Second occasion, you wanted time to file an IA for him.
I, my lord.
That's the whole thing. Otherwise, this issue was never raised.
My-
Today is coming up for the first time.
My lord, only anxiety is just, my lord, this work is stopped and my lords, there's monsoon will soon set in, my lords. If it's, my lord, we are not allowed to proceed, my lords. And even the valuation has also been conducted, my lords. I had placed a report on last date, my lord, last occasion, I placed a report. Wherein, my lord, representative of the opposite party were also present, my lords. Along with the photographs, my lords, they were present.
I'm sorry,
My lords, my lords.
this cannot. be.
My lord, review to come in, my lord, there has to be some change in
Apart from
circumstances.
review, you have other alternative remedies.
Alternatively, my lord, we could have pursued the arbitrator to present a report. My lord, in this case, my lord, the arbitrator is, the office of the arbitrator is absent. Because the divisional commissioner used to act as an arbitrator. Government of Assam, my lord, abolished the divisional commissioner. Now they have nominated an officer to act as arbitrator. But that has also been
What
not
do you say,
nothing is
Naya?
done, my lord.
My lord, as of now, the arbitrator has been nominated and most probably he'll be assuming charge within the few days. Most probably, my lord, that the government may. But insofar as our anxiety is concerned, my lord, our houses were not properly assessed. These are houses, my lord. If the houses are demolished, then what will be left to assess? That is why your lordships in the previous occasion, my lord, in the writ appeal, directed the CPW to assess.
Well, apart from technical issues, if
that
CPWD
assess-
comes and says that they have prepared a report and if it is presented to the court, my lord, this matter can be.
My lord, that assessment needs to be placed before the arbitrator. The order of the writ appellate court was very specific, my lord, and in fact, it was followed in some other writ petitions as well, my lord, directing CPWD. Well, that assessment needs to be placed. Otherwise, the arbitrator cannot decide the matter, my lord, without that assessment report.
And now, my lord, there is no arbitrator as of now.
No, as of now, one has been appointed. Nominated.
One retired IAS officer has been nominated, my lord. My lord, there is escalation of cost, and these are like, my lords, wards, my lord. At one point, it has stopped. It has led to, my lords, stay of work at other points also.
Well, the other parts can be done, my lord. Only our houses. The other parts can be done. And my lord, we were ready to vacate it if the assessment is done. Only on the assessment. If the house is not in existence, my lord, there cannot be an assessment.
I leave it to lordship, my lords. No doubt, my lord, there is some technical aspect to this matter, my lord, but that highway issue is, my lord,
Maybe public interest.
public interest is there, my lord.
Maybe.
Lordship
Maybe.
can mold the relief, my lord. Public interest is involved, my lord. This highway is stopped, construction has been stopped from last April, my lord.
Proceeding has been concluded in the writ appeal.
Yes, my lord.
Now, what more do you want?
No, my lord, writ appeal, there was a direction that valuation will be exercise will be
Oh.
conducted and submitted to the arbitrator.
Correct.
Now, my lord, the office of the arbitrator is not there. Secondly, my lord, CPW was sitting over the matter. Only when I came to the court, my lord, CPWD goes and conducts a exercise.
See, you are saying arbitrator has not been appointed?
No, my lord.
No.
No.
What does the order say? The 8th interim stay order dated 19/4/2023 passed by the arbitrator shall stand vacated.
My lord.
after the valuation report is prepared and presented in the arbitration proceedings.
my lord,
Still now the stay continues.
my lord.
Still now the stay continues, isn't it?
Still now, my lord, that is the problem I have approached this court, my lord. That is because due to that issue, my lord.
So you want this particular area to be,
Yes, my lord.
paragraph to be modified?
Modified, my lord.
How?
Modified in a sense, my lord, that that CPW may be directed, my lords, even to produce it before this court. If the arbitrator is not there, my lord, lordship will take that under
But
account.
the Nair saying arbitrator has been appointed.
My,
No,
has been
arbitrator
nominated.
my lord, not appointed.
Nominated.
Nominated, my
by
lord.
the state government. my lord.
State government nominates, central government appoints,
That's fine.
my lord.
So nomination has been done.
Yes, my lord.
Earlier, it was the divisional commissioner.
Hmm.
Now one retired person because of the abolishment of the
Divisional
division
commissioner.
commissioner's offices. One retired IAS officer has been nominated. The appointment has to come from the state.
Hmm. I don't think we can do it. Nothing.
Alright.
We are trying to help you out, but then there's nothing, no way to help you out.
The best course of action, if I may, my lord, is that if the state government and the central government are, my lord, if they press upon the central, because they are a central government agency for appointment, if that is expedited, that will help.
And
them, my
because
lord.
of, my lord, this specific particular order, my lords, other 6 to 7 petitions are also disposed in the same line, my lords. We are facing the same issue regarding that also, my lord. So it might be a slight a house here, my lord, but my lord, if we my lord, calculate, and if we, my lord, put it all together, my lord, there's a big patch, my lord, which has been stopped, my lords, from last April.
It's right. It's right.
And if we don't start work, my lords, from by now, my lords, we cannot do complete it within a time frame, my lords. It already been delayed by 2 years, my lords.
Who has filed this?
This is general manager, my lords. It's a general manager, my lords, of the NHIDCL.
It will be difficult to entertain this. Hmm?
Or let the, my lord, CPWD come. If they have any instructions, my lord, if they have conducted any survey at all, which to my instructions, they have conducted on survey, valuation exercise has been recorded in the record book. That can be presented to the, my lords,
Go by when this IA is not maintainable.
my lord.
How do you pass any orders?
That I will leave to your lordship, but my lords, there are certain, my lord, there are occasions, my lord, when reliefs are molded, my lords, and to review to come into place, my lord, there has to be change in circumstances. There's no change in circumstances, my lords. I tried to go through one Netaji Club case, my lords. There was a issue, my lord. It has been laid down when there is a change in circumstances, a review lies. But actually, my lord, we are not agreed by this order. Had we have been agreed, my lord, then we can come for review. And this is a retail, my lord. Where to go?
You study your case properly and then come back.
My lords.
Today we are not disposing it.
My lord. Then, my lord, let the matter be called after some time, my lord. Let Mr. Ranjit Dev Chaudhary come and let's apprise the court if any kind of, my lord's, evaluation exercise has been created by taken by
We're
CPWD.
talking about your maintainability of the IA only.
My lords.
You think about it and come back.
And then let it be listed on Friday, my lords.
Friday will be difficult.
Because, my lords, delay, my lords, public project and, my lords, cost escalation has been going on, my lords. Taxpayers'
That
money.
part we
My lords,
understand.
my lords,
But then we are also finding some difficulty to allow this IA.
my lord. My lords, normally when writ petitions or writ appeals are disposed of, my lords, normally, my lord, this approach is adopted. That courts can modify their own orders if something new comes to light, my lord. Here, my lords, arbitrator office is not there. And, my lords, that evaluation exercise was conducted. So we can, my lord, lordship may contemplate, my lords, or pass orders, my lord.
We list it on 22nd. You think about it and come back.
Well, let it immediately on reappointing, my lord.
Immediately also there's some difficulty.
My lord, could I pray for some accommodation on either 23rd or 24th?
Yeah, 24th.
23rd.
Can request made by T. Cooper, Leonard Council. Leonard Council.
Land
For
council
the-
for the applicant.
Applicant. List on the 24th.
Deeply.
How
appreciate.
late?
Item 10,
Oh, item 10.
Direct him, instead of-
My lord, this case relates to the condonation of delay, my lord, around 54 days, my lord. Since it is a matter of eviction, my lord, the delay part may be condoned, my.
My lord, I tried to file objection. I went to the record, my lords. The plea he has taken in his IA that there was a delay of 52 days in filing this writ appeal. Due to, my lord, they could not arrange the court fee. My lord, go to the record. He has filed only a court fee of 60 rupees, probably. 65 rupees.
No, my lord, they were labor, my lord.
65
Let them
rupees.
file the affidavit, my lord.
The lordship will go through, my lord. Lordship will
I have made a, my lord, I have made.
allowed. It can be allowed. But the only plea takes is that of a court fee, my lord, that is of 65 rupees. And to arrange 65 rupees, he takes.
No, my
52
lord,
days,
it is not only 65, my lord, they have to come from that place to Guwahati. They need some money, my lord, to pay lawyer
No
also,
explanation to that, my lords.
labor type person, my lord, and they do not have, my lord, that much money, my lord. As like my learned friend has, my lord.
Sir, he has money, my lord. He's filing writ upon writ, my lord.
So I made,
And
my
also,
lord,
on the same cause of action, he has filed another writ appeal, my lord.
that I'm giving number, my lord. That
Yes,
is, my lord,
same, my lord,
no,
same
not
cause.
same, not same.
He
of
goes to he goes to a single judge to modify that order. Single judge doesn't grant him interim, my lords. He was asked to come to a division bench on the same cause of action, my lord. He filed a second writ appeal, which is also,
My
my
lord,
lord, filed,
not that, my lord. Subsequently, my lord, another notice was issued. I challenged before the honorable single judge. Honorable single judge, my lord, declined it. So I preferred an appeal against that, my lord. The delay may be condoned, my lord. Both the case may come up together, my lord.
Also, we'll seek page 5, para 5, page 16, my lords.
That you have seen,
My lord?
that you have seen.
Yes, my
So
lord.
the 65 days we can condone.
No, no, lordship can condone, but my lord, the ground he has taken.
My lord, I honestly, I made a statement, my lord.
And lordship will see by, yes, my lord.
The other case, no.
Yeah, but we are in council for that.
It was not.
Also heard
Civil
Mr.
forest.
D. Gogoi, Leonard.
Standing counsel to the forest department.
Environment and Forest Department for the opposite party.
I am for, my lords.
4 and 7.
I'm correspondent number 5.
1 minute, 1 minute. Who appears 1, 2, and 3? 1, Chief
All-
Secretary,
I'm
1 and 5 I am appearing.
MS Arul Bora, Leonard Government Advocate appears for respondents 1 and 5. MS N. Borderland, Leonard Standing Council Revenue for the respond number 2 and 3.
I'm
2 and 3.
2 and 3.
2.
3.
D. Google and Standing Council Forest Department for respond number 3.
3, my lord.
And Mr.
Yes, sir, Raghavan.
Azhar Raval, Leonard Standing Council BTC for the
4, 6, and 7.
4, 6, and 7. Stop. By this application, the applicants are praying for condonation of 65 days delay
I do
in
comment.
filing the connected written papers. We have perused the course shown in the present application and we are satisfied. Accordingly, the delay of 65 days delay. And according delay of 65 days is condoned. Registry is directed to number the writ appeal and list the matter in its usual course.
My lord, can it be on Friday, my lord, since it is a eviction matter, my lord?
It's not yet numbered.
My lord, let it be numbered on Friday, my lord, because it's a eviction matter, my lord. During this winter, my lord, they take out any.
Yes, my lord. He will taken it to the consent order, my lord. He had sought time, my lord, to vacate the land. Let it
My
be
lord.
Friday, my lord.
Let it be on Friday, my lord, along with my lord, serial number, my lord, writ appeal 15879 of 23.
1, 5.
15879 of 23. Serial number, that other writ appeal.
That also is not numbered.
It will be numbered, my lord. It is, we have filed long back, my lord. Lordship
No,
kindly
no,
says.
no, no. Usual course.
My lord, can it be on Friday, my lord?
No. It is coming as usual course.
All lordship will make a mention on Friday, my lord.
Not on Friday. There will be difficulties. Friday,
No, we'll
Friday?
make a mention, we'll take a lordship will take up after Bihu vacation along with 2 matters. that, my lord, will make a mention, that observation be given. So that, my lord,
It's up to you that you can.
lordship,
mention.
another thing, my lord, I am very sorry to take indulgence, my lord. Item number 22, my lord, due to some medical issue, my lord, I have to leave court, my lord. Only for a day, my lord, I want accommodation.
On request made by Chair Pavel and also for the applicant. Yes, after 1 week.
Yes, man, I have informed the government side.
First, I'm standing counsel transfer in this matter. Inform there is some medical urgency.
After 1 week.
My lord, interim to be continued.
Interim order of procedure to continue. Till-
Lordship.
Item 12 and 13 for hearing.
Lordship, item 12 and 13, Your Lordship, I pray for some accommodation. In this matter, I'm being led by Mr. R. Borpujari. There has been a bereavement in his family, Your Lordship. So Lordship may kindly fix these two matters after 25th of January, Your Lordship.
Maybe on 30, my lord.
But M. Saranal and the council for the,
Respondent, my lord.
oh, you are for the respondent?
Yeah, applicant, my
Yes,
lord.
I have sought consent, Your Lordship, both the.
On request made on behalf of R. Babujari, Leonard. Standing council?
Yes, Your Lordship. Standing Council Revenue Department.
Revenue Department, list the matter again on, when
30,
30?
30 of January.
30.
I'm
I
deeply
love-
obliged, Your Lordship.
Item 14.
May it please your lordship, your lordship, may I kindly pass over the matter for the time being, as my senior is on leg in court number 4 with a series of cases.
Who's your senior?
Argedi Chaudhary.
You are for the appellant.
Yes,
You are appealing on behalf of the appellant.
responding.
Respondent.
Yes.
Arkadeep Chowdhury is the. Arkadeep Chowdhury is the central government.
I am for the appellant, your lordship.
Exactly.
For the appellant, your lordship.
After some time.
Yes, lordship. Oblige, your lordship.
Item 15.
Lordship, the matter may be passed over for the time being, as Mr. Kane Chaudhary is on legs. Obliged.
After some time.
Item 16.
Lordship, in this matter also, Mr. Kane Chaudhary is appearing, he's on legs. Who is it? You may start, I guess. Lordship, for some time, he is coming, he will be on it.
Okay.
He's coming.
Come.
Preliminary, till he joins. This is a PIL lordships,
Which one?
16.
16 you wanted up to some time, isn't it?
Chaudhary is on his way. So I'll just start. If lordship.
So if he's coming, then we'll have to take up the first item.
15.
Item 15. Oh, it's not there. No, we can proceed. Call out 17, item 17.
Item 17 and 18.
Yeah, Chowdhury.
My lord, Mr. Ken to senior counsel in dealing in the case, my lord, he is coming. Wherefore the respondent, my lord, they may start, my lord. He will reply.
Lordship is taking up for final disposal?
Yes.
No, no, I am asking the court, not you.
Yeah,
Yes, Lordship.
no, but provided all parties are ready. Chowdhury is there.
Yes, my lord.
All ready.
Yes, yes,
Item 17.
yes, yes. 17. Yes, my lord.
I am ready to, Lordship, so we can start. So the basic case here is, Lordship, we have challenging the learned single judge's order. The facts in a nutshell is that the writ petitioner, he was elected as president of Karimganj Jilla Parishad in 2019 with a tenure of 5 years. And there were some issues in between, and therefore on 28th of September 2021, a date was fixed for consideration and finalization of no confidence motion. The matter was fixed for no confidence motion on 28th of September. 2 days prior to that, he tendered his resignation on 18th September. The law is very clear. If you tender your resignation, it will become effective after 15 days. And in the meantime, during the course of that 15 days, he can withdraw it also. When you submit the resignation letter, it has to be submitted to the government, to the deputy commissioner. But for withdrawal, he have to directly approach the government and submit his withdrawal. In our case, the resignation was submitted through the deputy commissioner to the commissioner of secretary, commissioner and secretary of the Panchayat department. He withdrew the resignation by sending a letter to the deputy commissioner on 2nd of October. That is within the period of 14 or 15 days. 15 days. He addressed it to the deputy commissioner. It was not addressed to the government. He sent an email to the government, that deputy commissioner's letter. Our case is that he has not done his withdrawal as per the statutory provision. Later on, maybe he has realized and he has stated in his petition also that he had submitted another withdrawal letter to the government to addressing to the principal secretary of the department on 1st October, 1 day prior. Our contention of the state government is that, Lordship, he had submitted that letter on 8th of October. That is beyond the period of 15 days. So that cannot be acted upon, and therefore the government decided that the vice president should take over. And he accordingly took over also. They came before the learned single judge by filing the writ petition, and the learned single judge fully considered the case on the basis of the withdrawal letter addressed to the deputy commissioner on 2nd. According to the learned single judge, it was within time. But we have filed the appeal because the provision says it has to be given to the government, not to the deputy commissioner. Deputy commissioner is not the government under the statute. So when a particular procedure is laid down and particular authorities are designated under the statute, it has to be fully followed. There is no leniency, there cannot be dilution. So the learned, they have projected their case that they have submitted 2 withdrawal letters, one on 1st October, the other was on 2nd October. 1st October, according to them, was given to the government, which we agree, but we received it on 8th. And they have submitted the 2nd email and in WhatsApp on 2nd. But in the eye of law, under the statute, that is not a proper withdrawal application. So this is the case in a nutshell. So let me place the facts and the materials before this honorable court. If Lordship is pleased to take up his page 39. As Lordship is taking up a final disposal, I have to place the complete facts.
18/9/2021, he had tendered his resignation. And immediately, the deputy commissioner forwarded it to the principal secretary. So the meter has started, the countdown started from that day. Now, Lordship will kindly come to page 43, where I would like to say, I would like to emphasize that there was a meeting, and in that meeting, it was held that on 28th of September 2021, the no confidence motion will be considered. Page 43. As per the letter dated 6 September 2021, the Deputy Commissioner Kamrup, and as per notice dated 7/9/2021 of the Chief Executive Officer, a special meeting is held on to discuss and finalize the no confidence motion brought up by 9 numbers of Jilla Parishad members on 29/2021 at 11 a.m. in the conference hall of the Deputy Commissioner Kamrup. As instructed, the Vikram Dev Sharma, etc., chaired the meeting. At 11, Amolendu De, CEO, and 15 Jilla Parishad officials were present. The DDC apprised at the house that since Ashish Nath, President Karimganj Jilla Parishad, had submitted his resignation to the post of President Karimganj Jilla Parishad on 18/9/2021 to the Deputy Commissioner Karimganj, and which has been duly forwarded to the government by the DC Karimganj, the special meeting is hereby adjourned until further notification. So, the meeting got adjourned and he got a relief. The respite was there. Now, Lordship will kindly come to page 45. Then I will come back to page 44. Page 45 is the withdrawal letter. 2nd October to the Deputy Commissioner. Lordship will mark this. Page 45, 2nd October, written by Ashish Nath on 2nd October 2021 to the Deputy Commissioner Karimganj. Withdrawal of resignation from the post of President of Karimganj Jilla Parishad, Karimganj. I have the honor to inform you that I submitted resignation from the post of President of Karimganj Jilla Parishad on 18/9/2021. For the interest of public, I would like to withdraw my resignation from the post of President of Karimganj Jilla Parishad. So he made this application. This is on 2nd. Lordship will kindly now Lordship will come to the previous page. Page 44. This letter, according to was drafted much later by giving a date of 1st October. When he realized that he had made a mistake, on 8th, he wrote this with a back date of 1/10/2021. Here, Lordship will kindly see on 1st October, withdrawal of my resignation submitted on 18/9/2021 from the post of President, and it was addressed to the Principal Secretary, Government of Assam, Panchayat and Rural Development Department, Guwahati 6. A reference has been given, that resignation letter and the communication of the Deputy Commissioner to the government. With reference to the subject cited above, I am, being the President of Karimganj Jilla Parishad, hereby withdraw my resignation submitted on 18/9/2021 before the DC Karimganj from the post of President under Section 72(1) of the Assam Panchayat Act 1994 due to demand of public as well as members of the Jilla Parishad. The said resignation letter dated 18/9/2021 was also communicated by the Deputy Commissioner Karimganj to your honor for provide communication, etc. dated so and so. Therefore, in my humble request before your honor, kindly to take necessary steps as per provision 72(1) of the Assam Panchayat Act 1994 and thereby allow me to continue as the President of Karimganj Jilla Parishad, and for this act of kindness, I shall remain grateful to you forever. This letter was written on 1st. He has complied as per 72(1). If it has been done as per 72(1) on 1st October, there was no necessity of writing another letter on 2nd to the Deputy Commissioner. The next page 45, there is no reference of the earlier letter. If Lordship comes to the next page 45, there is no reference, neither resignation letter nor the 1st October's letter. And there was no necessity. In fact, he committed a mistake later on. Maybe he was well advised by some legal experts. So this was an afterthought. All these things. Now, what exactly he had stated in reference to Annexure 5 and Annexure 4 in his writ petition? Lordship will kindly come to paragraph 8, page 31. That it is submitted that Section 72(1) of the Assam Panchayat Act 1994 provides resignation or removal of the President and Vice President. A member holding the office of President of the Jilla Parishad may resign his office at any time by writing and send it to the government through the Deputy Commissioner. Lordship may kindly mark it through the DC, that resignation letter. And the President, Vice President of the Jilla Parishad may resign his office at any time by writing and send to the President of the Jilla Parishad, and in absence of the President to the government through the DC, and the office shall become vacant on the expiry of 15 days from the date of such resignation, unless within that period of 15 days he withdraws such resignation by writing and send it to government. There is no role of Deputy Commissioner here. And send it to government. He withdraws such resignation by writing and send. So he have to write to the government and he will have to send it to the government. So he withdraws such resignation by writing and send it to government in respect of the President and to the President in respect of the Vice President, as the case may be. This is now his submission. It is respectfully submitted that the petitioner submitted his withdrawal letter on 1/10/2021 before the Principal Secretary of Government of Assam Panchayat and Rural Development Department, and on 2/10/2021 again submitted a communication of his withdrawal of the resignation to the DC Karimganj for information. Now, here I am pausing here for once again and coming back to page 45. Page 45. Now he say, according to him, the second letter, 2/10/2021, again submitted the communication of his withdrawal for information to the DC. Now, Lordship will kindly see the language here. It is not for information. It is his withdrawal. I have the honor to inform you that I submitted resignation from the post of President of Karimganj Jilla Parishad on 18/9/2021. For the interest of public, I would like to withdraw my resignation from the post of President of Karimganj Jilla Parishad. But his submission and his pleading says that for information about the 1st October's letter, he wrote the second letter. If coming back to page 32, once again, I'd like to read. It is respectfully submitted that the petitioner submitted his withdrawal letter on 1/10/2021 before the Principal Secretary to the Government of Assam Panchayat and Rural Development Department, and on, that is the second, on 2nd October 2021, again submitted a communication of his withdrawal of resignation to the Deputy Commissioner Karimganj for information. This is not for information, Lordship. Had this been information, he would have made a reference of 1st October's letter. It is not for information. He tendered his resignation and he withdrew the resignation before the Deputy Commissioner. On receipt of the information dated 2/10/2021, the Deputy Commissioner Karimganj acted as per government, contrary to the provisions of 72(1) of the Assam Panchayat Act. Now, going further, the 2nd October's letter he wrote, and he had placed at page 24. He submitted it through WhatsApp and it was seen. There is no denial on that from our side. And it was forwarded to the PNRD department email also page 25. On the basis of this, Lordship, the government, the Deputy Commissioner wrote another letter on 5th October, page 49. Here it is said by the Deputy Commissioner, this was put to challenge. There are two writ petitions. It's a common judgment. The first writ petition basically challenged the communication of 5th October. 5th October, let me place it. The Deputy Commissioner Karimganj wrote to the Chief Executive Officer Karimganj Jilla Parishad withdrawal letter submitted by Ashish Nath, President Karimganj Jilla Parishad. With reference to the subject cited above, I would like to apprise that one withdrawal letter submitted by Ashish Nath, President Jilla Parishad Karimganj, in connection with his resignation letter dated 18/9/2021, which was forwarded to the Principal Secretary of the Government of Assam Panchayat and Rural Development, Dispur, behind this office letter dated 18/9/2021 by the undersigned. It may be mentioned that the aforesaid withdrawal letter is received on 4/2/2021 after the expiry of the statutory period, that is 15 days from his date of resignation, that is 18/9/2021, from the post of President Karimganj Jilla Parishad, as envisaged in section 72(1) of the Assam Panchayat Act, which states that the office shall become vacant on the expiry of 15 days unless within the said period of 15 days he withdraws such resignation by writing and send it to the government in respect of the President. Hence, you are requested to take further needful action into the matter with intimation to this end. So actually, there should be an order that the Vice President should take over. So that order was passed on 11th. Immediately, one writ petition was filed. Now, all subsequent consequential orders were put to challenge, and that another order at 11th October 2021, page 37. This is from the Principal Secretary of the Government of Assam Panchayat and Rural Development to the Deputy Commissioner. Page 30. Oh, I'm sorry, Lordship. It will be 91. From the Principal Secretary to the DC Karimganj, reference regarding resignation of Ashish Nath, your letter dated 18/9/2021. That is the resignation letter. With reference to your letter on the subject cited above, I have the honor to inform you that the resignation of Ashish Nath, President Karimganj Jilla Parishad, is hereby accepted as per provision of section 72(1) of the Assam Panchayat Act. Further, the Vice President of Karimganj Jilla Parishad is hereby entrusted with the responsibility vested upon him under section 77(2) of the Assam Panchayat Act 1994, as amended, to act as the President in charge of Karimganj Jilla Parishad on temporary basis until further orders. So this was put to challenge in the subsequent writ petition. Then there is another order of 19th October. It was part of the second writ petition. To the Chief Executive Officer, the Deputy Commissioner issued another letter to the CEO of the Karimganj, where it has been stated, with reference to the subject, I would like to enclose here with the government letter under reference regarding acceptance of the resignation of Ashish Nath, President Karimganj Jilla Parishad, as per provision of 72(1) of the Panchayat Act 1994, which speaks for itself, and request you to take necessary action as per the instructions prescribed in the government letter with due intimation to this end. So the government reference letter is 11th October, by which a Vice President was allowed to take charge. And on 19th October, next, page 95, 93. Here the joining report. So all these are put into the subsequent challenge. Now the core question here is, on which date although the learned single judge did not give any reference to the 1st October's letter, the whole case was decided on the basis of the 2nd October's letter addressed to the deputy commissioner. And according to the learned single judge, let me place that paragraph so that our main ground and main area of grievance will be properly highlighted. Paragraph 19. 151. 150. 150. The petitioner has asserted to the effect that apart from sending the letter of withdrawal of resignation to the jurisdictional deputy commissioner, he had sent email to the Panchayat and Rural Development Government of Assam in its email account, date number so and so, with the same letter of withdrawal of resignation on 2nd October 2021. With such assertion, the petitioner has contended that he had performed the process required on his part to withdraw his resignation by sending the letter of withdrawal of resignation to the government in the Panchayat and Rural Development Department within the stipulated period, that is, within the period of 15 days from the date of submission of the letter of resignation on 18/9/2021. The respondent number 1 in his affidavit opposition has not denied about sending the letter dated 2/10/2021 in the official website of the Panchayat and Rural Development Department on 2nd October 2021. A stand has been taken to the effect that on 2nd October 2021 was a holiday, being the Gandhi Jayanti, and the next day, 3rd October 2021 being the Sunday. The letter dated 2nd October 2021 was received after resumption of the normal office hours. It has been pointed out that the signed copy of the letter of withdrawal of resignation forwarded by the Deputy Commissioner was received on 27th October 2021. By such stand, a plea has been sought to be raised on behalf of the state respondents that the act of withdrawal of resignation performed by the petitioner was beyond the period of 15 days from 8/10/2021. Thus, plea in the considered view of this court is not tenable because the government statute has cast an obligation to the holder of the office of the President of Jilla Parishad not only to send the letter of withdrawal of resignation to the government within 15 days from the date of submission of the letter of resignation. By sending the letter of withdrawal of resignation to the email account of the government in the Panchayat and Rural Development Department, the petitioner had taken the requisite steps as may be reasonably required on his part to inform about his intention to withdraw his earlier letter of resignation to the government in the ordinary course within 15 days period. And it is another matter whether or not the fact of such withdrawal letter of resignation had actually known or not to the government within 15 days time period, because the act of withdrawal of resignation being also of unilateral character. The conditions laid down in section 72(1) of the Assam Panchayat Act is fulfilled when the holder of the office of the President of Jilla Parishad takes the necessary steps for sending the letter of withdrawal of resignation within the stipulated period by ensuring that it reaches the proper destination, that is the government, in course of time. The court is also not oblivious of the proposition that a provision relating to giving or sending a notice calls for a liberal interpretation for the person who has the statutory obligations of giving or sending a notice, because he is presumed to be the loser in the process, and it is for the safeguard of his interest. The very provision has been incorporated in the statute. In the case in hand, the petitioner has been seen to have performed the act of sending the letter of withdrawal of resignation to the government within 15 days from the date of submission of the earlier resignation on 18/9/2021. By sending the email to the email account of the government PNRD resignation from the post of President Jilla Parishad, Karimganj. From the discussion made above, it is already found that the time period available to the petitioner's disposal to withdraw his letter of resignation was up to 4/10/2021, and the petitioner had performed the act of withdrawal of resignation within the stipulated time period. Though a question with regard to the admissibility of the letter of withdrawal resignation sent by email on 2nd October 2021 has been raised, but acknowledgement of receipt of the signed copy of the said letter on the later date by respondent number 1 in his affidavit has substantiated the fact that of sending the letter of withdrawal of resignation by the petitioner within the stipulated period of 15 days. Thus, the decision referred to by the learned departmental counsel on the admissibility or otherwise appears to be not of relevance in the case in hand. In such view of the matter, the court is of the considered view that the office of the president of the Karimganj Jilla Parishad did not cease to have vacated by the petitioner at any point of time, contrary to the view taken by the state respondent authorities. So the learned single judge totally relied on the letter written on 2nd October. Our whole case now in the appeal, that the withdrawal letter of 2nd October is not a withdrawal letter in terms of the statute, provisions of 72(1). Let us now come to the provisions of 72(1). If Lordship is pleased to take up the, although I have read it from the quoted part, but let us look it from the book now. And I'll also place what was our stand in the affidavits and what is their stand. More bottle pani ki kotha. Got it? (72) Resignation or removal of the president and vice president. 1. A member holding the office of president of the Jilla Parishad may resign his office at any time by writing and send it to government through the deputy commissioner, and the vice president of the Jilla Parishad any resign his office at any time by writing and send it to the president of the Jilla Parishad, and in absence of the president to the government through the deputy commissioner. And the office shall become vacant on the expiry of 15 days from the date of resignation, unless within the said period of 15 days, he withdraws his resignation by writing. Lordship may kindly mark, by writing and send it to the government. So he will have to write it to the government. Deputy commissioner is not the government, Lordship. The principal secretary is the government, which they have realized later on. Therefore, that first letter, purported letter of withdrawal of first October's letter was addressed to the principal secretary of PNRD department. Such resignation by writing and send it to the government in respect of the president and to the president in respect of the vice president, as the case may be. So the law is very clear. There is no ambiguity that for withdrawal, you have to write to the government and it cannot be channelized to the deputy commissioner. You have to go and submit, or you can send it directly to the government. So our case here is, Lordship would kindly take our affidavit. Lordship will kindly come to page 96. Regarding the statements made in paragraph 3 of the humble deponent begs to state that the department has received the resignation letter dated 18/9/2021 of the petitioner resigning from the post of president of Jilla Parishad on 8/10/2021. Accordingly, the matter was processed, and with the approval of the Honorable Minister, Panchayat and Rural Development Department, the resignation of the petitioner from the post of president of Jilla Parishad was accepted, and same was in communicated by letter dated 11/10/2021 by the office of your deponent to the Deputy Commissioner Karimganj, along with the copies of the Commissioner Panchayat and Rural Development, Chief Executive Officer, Karimganj Jilla Parishad, and Secretary, Assam State Election Commission. Now, this is very critical. Next paragraph. The deponent begs to state that the office of your deponent received the withdrawal letter of resignation dated 1/10/2021 from the petitioner Bhai DY number 2759 dated 8/1/8/10/2021 after the expiry of the stipulated 15 days period as prescribed under the provisions of section 72(1) of the Panchayat Act. So the actual letter as contemplated, as envisaged under the statute, they have made a reference that it is of 1st October. We have received it on 8 October. And what he has said, he took several different stands at different petitions and different pleadings. If Lordship is pleased to come to paragraph 5, page 32. It is so here in the main writ petition, he has taken the stand that he has submitted. That means he went and presented the withdrawal letter before the commissioner and secretary. What is submission? Submission is that I am going and I am placing it. This is my withdrawal letter. I am submitting it. Now, if Lordship is pleased to come to page 125. I'm sorry, page 125 also. Here also he has said, reply to the petitioner. Yes, the last line. Therefore, the withdrawal of resignation letter 1/10/2021 have been sent to the government. Now he has changed his stance. So Lordship will kindly mark the word sent here. Within the statutory period of 15 days, that is 4/10/2021, government is bound to accept it considering the language and mandate of section 21 of the Panchayat. It is pertinent to mention that the receipt of the said withdrawal letter dated 1/10/2021 is not disputed by the government. Yes, we have not disputed. What we have stated in our affidavit that we received it on 8. We received it, but we received it by a dispatch number of 8 October 2021. Time is of essence. Time is very crucial. Time is very critical here because that 15 days period expires on 4th. Further, I am going further. It is respectfully submitted that once the factum of sending the withdrawal letter within the prescribed period of 15 days, time is proved, the receipt of the same by the government becomes immaterial. We fully agree. We fully agree to this statement. He says it is respectfully submitted once the factum of sending. So now, he have to clarify before this honorable court with proof that whether he had submitted or whether he has sent. He sent the withdrawal letter of 2nd October by email and also by WhatsApp. Here he is totally silent. If he had sent, he must have a postal receipt or an email reference or a WhatsApp reference. He is neither placing anything before this honorable court that by what mode of communication he had sent the letter of 1st October to the government, either by WhatsApp, either by courier, either by email or any other mode. He can go and personally deliver it also because his writ petition says he has submitted. Later on, when we said that we received it on 8, then he said, we sent it. That means he want to project a case before this honorable court that he had posted or sent it by a different mode of communication. But that he will have to clarify. It's a disputed fact now. In disputed fact, the writ court will not enter. So here he says, it is pertinent to mention, page 26, I am reading further. It is pertinent to mention that the receipt of the said withdrawal letter dated 1st October 2021 is not disputed by the government. It is respectfully submitted that once the factum of sending the withdrawal letter within the stipulated period of 15 days is proved, the receipt of the same by the government becomes immaterial, in as much as the mandate of sending the withdrawal letter by law is satisfied. It is also respectfully submitted that the legislative intent of section 72(1) of the Act of 1994 is very based from the date of resignation and not the receipt of thereof by the government. In the present case, the withdrawal letter having been sent to the government within the prescribed time limit, the mandate of section 72 in respect of withdrawal of resignation in question has been duly satisfied. Now, he has failed to give any proof on which that he sent the letter of 1st October. Absolutely no proof, nothing. In one place he said submission, the other places he has referred that it is sent. In another reply at page 130 also, he said, Lordship may kindly come to page 130, preliminary contention. Before adverting to the respective paragraphs, the deponent craves leave to raise a preliminary objection in respect of the counter affidavit filed by respondent number 5. It is stated that the deponent, by his letter dated 1/10/2021, submitted before the Principal Secretary to the Government of Assam, had duly withdrawn his resignation letter, which satisfied the requirement of section 72. So now, here in the reply to the private respondent is that he submitted it before the Principal Secretary. He is very cleverly, he has not said on which date he has submitted. He referred about the letter. In fact, he went to the office on 8th and he submitted in the disperse section. He did not go before the Principal Secretary, and Principal Secretary is a responsible officer. He will not say anything wrong before this honorable court on oath. He said that we received it on 8th. Absolutely correct, with a reference number, disperse number. He went to the office. He submitted the letter there. The reference is given, and it went to the Principal Secretary. Principal Secretary rightly on affidavit said that we received it on 8th. There is no denial on that. But here he says he submitted it on 1st. If he had submitted on 1st, in the writ petition he would have said, he would not have said that he had sent it, page 126. In our reply to the state government's affidavit, he said, we have sent it. To the affidavit filed by the private respondent, he said, I have submitted it. So he have to first clarify. Although the learned single judge did not take note of all these things, and while coming to the conclusion, totally relied upon the letter of or email of 2nd October, which in the eye of law is not a proper withdrawal letter. We cannot dilute the statutory provisions that way, Lordship. Writing to Deputy Commissioner and writing to the Principal Secretary are two different events, which is not contemplated under the Act, writing to the Deputy Commissioner. So the law very clearly says, unless within the said period of 15 days, he withdraws such resignation by writing and send it to the government. So he will have to write to the government, he will have to send it to the government. And if he had sent it on 1st October, let there be a postal receipt or any other proof, Lordship, he would have complied. So they are finding fault in our action. So first you have to satisfy this honorable court that you have rightly complied as per the timelines given under the statute. The timeline is that within the 4th of October, you have to submit to the government. He neither sent, neither posted it, nor sent it to email, nor personally went there. He went there on 8th. He was in Guwahati, that's why he could submit it personally on 8th, because on 7th, the other writ petition, the first writ petition was filed here. And I have submitted that. He must have got some proper advice at a later stage that it should have been written to the principal secretary. And therefore, the withdrawal letter, purported withdrawal letter of 1st October is properly drafted also, giving reference to section 72(1). In the first email of 2nd October, there is no such reference. Simply says, I am withdrawing because of public pressure and because of pressure from my other members of the. In the second affidavit or second writ petition also at page 61. Paragraph 5. Page 61. That it is stated that on 1/10/2021, the petitioner submitted the communications for withdrawal of his resignation letter dated so and so due to public demand. So where he has submitted, we have to know from them, Lordship. So here also on oath, that is why, Lordship, in my document, Lordship, they have not mentioned about the paragraphs in the affidavit. Whether it is based on records or knowledge, nothing. It is blank, the service copy. So again, he has said that I have submitted. Yes, he has submitted the 1/10/2021, but before whom and on which date? And in the same proceedings, in the reply, two replies, in one reply he says he has submitted, one reply he has said sent.
Issue is whether it is sent or received, I think.
Issue is whether that letter,
As per Section
that withdrawal
72.
letter, which is the correct form of withdrawal. The correct form of withdrawal is whether it should be addressed to the deputy commissioner or to the government. That is issue number 1. If it is to the deputy commissioner, he has complied. Because on 2nd, he sent the email, we received it. Although it was a holiday, doesn't matter, Lordship. He sent a copy to the government also, that same deputy commissioner's letter. It received by the government, maybe on 4th because the holidays, nobody opens the office mail. But that is also not disputed. We are not denying. But whether a letter of withdrawal addressed to the deputy commissioner fulfills the statutory requirements of section 72(1. Unless this section is challenged, the language is very clear. You have to write the letter and send it to the government. Write the letter to the government, send it to the government. And therefore, he himself has admitted that. He himself says, page 32, coming back once more. May I read, Lord? The 6th line from bottom, page 32. After the legal advice, he become wiser. Therefore, it has been incorporated there in their own pleadings. That the aforesaid provision provides for submission of application of withdrawal to the government only. He knows that it is not deputy commissioner. They have inserted the word only here. And the writ petition was filed on 7th. So they may give some good advice from good expert lawyers, and they have decided that we have to submit a proper application of withdrawal to the government, which they have done. And in our affidavit, in very clear, without any ambiguity, we have stated, page 97, once more. The statements made in paragraph 5 of the petition, your humble deponent begs to state that office of your deponent received the withdrawal of resignation letter dated 1st October 2021 from the petitioner. From the petitioner, it has been laid. From the petitioner via DY number 2759 dated 8 October 2021. That is after the expiry of the stipulated 15-day period as prescribed under the provisions of the section so and so. And if Lordship is pleased to look at the affidavit, these are on record, page 102. On record, we are saying that we have received it from the petitioner on 8. And what is their response to this, Lordship? Immediately, they have shifted their stance. Reply to, yes. Yes, page 124, that is their reply. Ashish not so and so. So in the paragraph I showed just now was paragraph 7. So what is their response to paragraph 7 now? Page 125, parawise reply. While denying the statements made in paragraph 7 of the said affidavit in opposition, the answering deponent begs to state that having regard to section 9 and 10 of the General Clauses Act 1897, the 15 days contemplated in section 72(1) expires on 4/10/2021. In view of the fact that 2nd October being a holiday on the occasion of Gandhi Jayanti and 3rd October being a Sunday respectively, therefore withdrawal of resignation letter dated 1/10 having been sent to the government within the stipulated period, that is 4/10/2021, the government is bound to accept it. So now they have changed the position that we have sent it on 1st. In their petition, they said we have submitted. In our affidavit, we have accepted, they have submitted. They did not disclose the date on which they have submitted in their petition. In our affidavit, we have clarified before this honorable court on record by giving the reference number also that he came and personally submitted the withdrawal letter of 1st October on 8th of October, which is beyond 4th October. So now he has changed his stance that we have sent it. Now let us find, let us accept that they have sent. Where is the proof of sending? Writing a date on a particular letter with computer typing, Lordship, will not make the position different. I can put any number of dates.
Right, yeah.
Lordship.
Just 3 minutes.
Lordship. Why 3 minutes, Lordship? 5 minutes. The learned single judge wholly dependent on the withdrawal letter of 2nd October, not the 1st October. So my case is that the correct version of the withdrawal letter is 1st October's letter, but it was not timely submitted. So therefore that 15 days period is over. So my second argument is that if the 1st October's letter is taken into consideration for the purpose of withdrawal, it can still not be able to take considered on the simple reason, for the simple reason that it was submitted on 8, which is beyond 4. So these are my two limb of arguments. The law is very well settled. In response of the 2nd October's letter, it was not addressed to the government. It was addressed to the deputy commissioner. It will not be complying the provisions of the statute. The competent authority as envisaged under section 72(1) is the Principal Secretary, Panchayat and Rural Development Department, and the competent authority is not the Deputy Commissioner of Karimganj. On the other hand, the rightly written withdrawal letter was addressed to the Principal Secretary, Principal Secretary of PNRD Department on first, but it was submitted after the period is over, and they have not been able to satisfy this court on which date they have submitted. According to us, it is 8th of October. If they have submitted it earlier, they have to adduce evidence, which they have not done. In fact, they are not sure about whether they have submitted it or they have sent it. Submission meaning is different, sent meaning is different. These are basic meaning in English, Lordship. We do not have to open the law dictionary for this. When I submit it, I go and place it. When I sent it through various modes of communication. It can be various electronic modes or various physical modes through courier service by postal department. And I can send a messenger also to submit it. So they are not sure by what mode they have sent it. On the contrary, they have also said that we have submitted it. So they have to clarify all these things. In support of my case, Lordship, I would like to place 2-3 judgments. One judgment of the Bombay High Court Division Bench, although it is not binding, but straightway on the same point, the Honorable Bombay High Court said that if the statute provides a particular way of withdrawal of resignation, it has to be done in that manner. It has to be submitted to the competent authority. So Maharashtra Jilla Parishad Councillors and Panchayat Samitis Members Resignation Rules 1962, Dhanu Singh versus State of Maharashtra. Two propositions are here. One is, Lordship, how the resignation has to be submitted, and if it is not complied with the statute provision, it is not a resignation or withdrawal of resignation in the correct form. And also, if there is disputed question of facts, then 226 is not the forum. There are a series of cases. I do not have to place any judgment on that. But on the other point, Lordship, paragraph 3. It was contended by the learned counsel for the petitioner that the petitioner neither tendered his resignation to the appropriate authority, that is chairman, nor any acknowledgement was issued by the appropriate authority. And therefore, there is a clear violation of the provisions of Rule 3 and 6 of the Rules of 1962. It is submitted that this fact has not been disputed by the respondent number 3 in para 4 of the affidavit in reply filed by respondent number 3. It has been specifically stated the petitioner submitted their resignations before respondent number 2, that is block development officer, who is not the appropriate authority. The appropriate authority to whom the resignations are required to be tendered as per procedure prescribed was the chairman of Panchayat Samiti, and acknowledgement was not issued in this regard as required under Rule 6 of the Rules of 1962. Coming to Lordship, paragraph 11, page 665. We have given anxious thought to the various contentions canvassed by the respective counsels for the parties. The issue involved in the petitions need to be considered in the light of various provisions of the Act of 1961 and the rules of 1962 and 1965. Section 60 of the Act of 1961 provides that the procedure for tendering resignation as member of Panchayat Samiti and to whom it should be addressed and handed over. Section 60 contemplates that any member of Panchayat Samiti may resign his office by writing under his hand addressed to the chairman of Panchayat Samiti, and on tendering such resignation as per the procedure stipulated in Section 60 by the members of the Panchayat Samiti, the office of such members shall become vacant. Rule 3 of the Rules of 1962 stipulates that the letter of resignation by the member of Panchayat Samiti shall be tendered to the appropriate authority, that is chairman of Panchayat Samiti as mentioned in Rule 2B of the 62 rules, either by delivering it personally or through any persons duly authorized by him in this behalf or by registered post acknowledgement due. Similarly, Rule 6.1 of the Rules of 1962 stipulates that on receipt of the letter of resignation, the appropriate authority, that is the chairman of Panchayat Committee, shall forthwith acknowledge the same, and such acknowledgement shall specify the time and date on which the letter of resignation was received. Rule 6.2 makes it obligatory on the appropriate authority to inform the persons tendering the resignation in writing by registered post, acknowledgement due, the date from which the resignation shall become effective under Rule 4. Rule 4 of the 62 rules contemplates that a resignation tendered under Rule 3 shall take effect from the 7th day from the date of which it was received by the appropriate authority. In the instant case, it is not in dispute that the petitioner are alleged to have submitted their resignation to Block Development Officer Panchayat Samiti Mahagaon and not to the chairman of Panchayat Samiti as required under Rule 3 of the 1962 rules. Coming to the next page. First two lines. And therefore, tendering of alleged resignation by the petitioners is not in conformity with Rule 3.1 of the Rule 1962. Coming to
Where are you reading from?
first line, that's submission. Therefore, tendering of alleged resignation by the petitioners is not in conformity with Rule 3.1 of the Rules of 1962. Page 666. Now coming to paragraph 15. In the instant case, the letter of resignations were alleged to have been tendered by the petitioners on 23/12/2010, and respondent number 3 have gave effect to them from the same date, that is 23/12/2010. This act of the respondent number 3 is in complete violation of Rule 4.1 of the Rules of 1962, which contemplates that the resignation tendered under Rule 3 shall take effect from the 7th day from the date on which it is received by the appropriate authority. It is therefore evident that resignations alleged to have been tendered by the petitioners were not as per the mandatory procedure stipulated in Rule 3.1 of the Rules of 1962. The respondent number 3 also did not follow another mandatory requirement stipulated in Rule 6.1.2 as well as Rule 4.1 of the Rules of 1962. There cannot be any quarrel on the proposition that when an obligation is created by the statute to perform the act in the manner as provided under the said statute, then in case of its non-performance, the effect would be that the action taken by the authority would be rendered invalid in law. In the instant case, it is difficult for us to hold that the submission of resignations by the petitioners and acceptance thereof by the respondent number 3 were not being in conformity of Rule 3.1, 4.1, 6.1, and 6.2 of the rules. The office of the members of Panchayat Samiti shall become vacant, and therefore the impugned communications is unsustainable in law. So here, the resignation letter has to be submitted before the chairman of the Samiti and not before the BDO. So that provision has to be strictly abided by. This is the ratio of this case, Lordship. So my humble submission is that when the law is well defined, the procedure is well defined, then it has to be done in that manner and in no other manner. Yes, I can. Another judgment, one single line will be important. AIR 1969, Supreme Court, page 180. Rajkumar versus Union of India. Paragraph 5. Paragraph 5. Our attention was invited to a judgment of this court in the state of Punjab versus Amar Singh Harika, AIR and so, in which it was held that an order of dismissal passed by an authority and kept in the file without communicating it to the officer concerned or otherwise publishing it did not take place as from the date on which the order was actually written out by the said authority. Such order could only be effective after it was communicated to the officer concerned and was otherwise published. So what I am trying to emphasize from this ratio is that, Lordship, the competent authority as envisaged under section 72 is the Principal Secretary, Panchayat and Rural Development Department. So it has to be addressed and it has to be submitted to him. Email on 2nd October to the Deputy Commissioner regarding withdrawal is not in consonance with the law or the statutory requirements under section 72(1) of the Panchayat Act of 1974. So therefore, the learned single judge, in my humble submission, Lordship, with all humility, has totally misdirected himself by taking into consideration the 2nd October withdrawal letter, which in fact is not a proper and statutory withdrawal letter. Whole judgment was delivered on the basis and on the foundation of the 2nd October. And there is no discussion on the 1st October's letter. 1st October letter in its form is correct, but it was time barred. Had it come before 4th of October, it would have been acted upon as per the statute. But it reached after 4 days. There is a delay of 4 days. And that delay of 4 days is fatal. The office has already become vacant. Automatically, there is no requirement of, it is a, learned single judge has rightly said, it is a unilateral action. There is no requirement of acceptance of the resignation letter. Once a resignation letter is submitted, after 15 days, the office will automatically fall vacant. So on 5th of October, it has fallen vacant. There is no requirement, although that they put the government various communications after 11th of October said that we have accepted the resignation, etc., etc. This has no meaning under the statute. These are regular administrative communications. It does not have any statutory backing. The statutory backing is, Lordship, the resignation letter and the withdrawal letter. Whether the resignation letter after 15 days, it has become active or not. If they have withdrawn it within 4th, then, Lordship, the withdrawal letter of 18th of September will become redundant. Taylor versus Taylor. Huh? One more judgment, Lordship, that Taylor versus Taylor reference for that purpose only. 2022 9 SCC page 1. Principal Commissioner of Income Tax versus ABC Papers. Paragraph 14. This is Nur Muhammad versus Khurram Pasha. Paragraph 14. The remedy for failure to pay interim compensation as directed by the court is thus provided for by the legislature. The method and modality of recovery of interim compensation is clearly delineated by the legislature. It is well-known principle that if a statute prescribes a method or modality for exercise of power, by necessary implications, the other methods of performance are not acceptable. While relying on the decision of the Privy Council in Nazir versus King Emperor, a bench of 3 judges of this court made the following observation in State of UP versus Singhara Singh. In Nazir Ahmed's case, the Judicial Committee observed that the principles applied in Taylor versus Taylor to a court, namely that where a power is given to do a certain thing in a certain way, a thing must be done in that way or not at all, and that other methods of performance are necessarily forbidden, applied to judicial officers making a record under section so-and-so. So, if we follow this principle, the withdrawal letter to the Deputy Commissioner is forbidden. It is not a withdrawal letter in the eye of law. The statute does not contemplate it. Statute in very, without any unambiguity, says that the withdrawal letter should be written to the government and it should be sent to the government, which they have done, but after 4 days. This is my humble submission, Lordship. If they dispute the factual things, then Lordship, the appropriate court will be the civil court. If they have actually submitted before 4, that 1st October's letter, they have to adduce evidence, they have to adduce proof, which they have not done before this court under Article 226. And this honorable court is not a fact-finding board to do all these things. They have to satisfy this honorable court. In that view of the matter, Lordship, the learned single judge erred in considering the 2nd October's letter, which has no statutory backing, and there is no discussion on the 1st October's letter. On that 2 grounds only, the impugned judgment may be interfered with. This is my humble submission.
May it please, Your Lord. My Lord, my first submission would be the learned single judge has recorded a finding of fact that the resignation was withdrawn within time limit. So over a finding of fact, when a court exercising discretion does it, my lord, against that an appeal does not lie. Secondly, my lord, assuming what the other side is contending is correct, this is another view. Merely because another view is possible, a writ appellate court will not interfere. On legal principles, these are my 2 preliminary objections. I'll elaborate it little later. Now let us come to the facts of the case. Now on 18/9/21, the respondent writ petitioner, my lord, submitted his resignation. Then the meeting was slated on 29/21. But due to the resignation, my lord, the meeting stood adjourned. Now, my lord, in terms of section 72, a resignation can be withdrawn within 15 days. If it is withdrawn, well and good. If it is not withdrawn, by legal fiction, my lord, it will have its effect. Now, Lord, I couldn't understand one argument. The principal stand of the state is the resignation as a withdrawal was not in form as prescribed. Then why the principal secretary accepted it on 11/10? These are all self-defeating arguments, man. If the withdrawal was wrong, if it is honest in the eye of law, what was the requirement on the part of the principal secretary to accept it? That means you received it. You acted on it. Question is when you received it. Even if it is 4th, my lord, by virtue of section 10 of the General Clauses Act, 2nd of October is the, my lord, birth anniversary of the father of the nation. It was a holiday. 15th day was 2nd. 3rd was a Sunday. On 4th, my lord, it was undoubtedly it was received. Everybody has acknowledged that it was received on 4th. So by virtue of section 10 of the General Clauses Act, the withdrawal was within 15 days. Kindly have the General Clauses Act for a moment, my lord. I am clearing points one by one, my lord. 2nd October was holiday, 3rd October was holiday. So 4th was the 15th day. So there is no dispute, my lord. In para 8 of the affidavit in opposition also it is clearly stated. And it was clearly received in the government website on 2nd. Please come to section 10, my lord. Where by any central act or regulation made after commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed period, then if the court or office is closed on that day or the last day of the prescribed period, the act or proceeding shall be considered as done or taken in due time if it is done or taken on the next day afterwards on his court or office is open. Second was the 15th day. Second is a holiday. Third is a Sunday. So the following day is Monday, that the next day. That's the fourth. So even if it is, we take as fourth, my lord, it was within 15 days. So therefore, there is nothing wrong on the part of the learned single judge in taking that particular view at para 9 of the impugned judge, 19 of the impugned judge. Now, my lord will kindly come to page number 82. No, yes, 822. My lord will kindly take the paper book of 289. It is undoubtedly addressed to the Deputy Commissioner, my lord. I'll come to that, sending it to the government part little later. So the first point which I cleared off is section 10 of the General Clauses Act, which says on the reopening day also if it is done, then it will be in compliance of the statutory prescription. I have the honor to inform you that I submitted resignation from the post of President of Karimganj Jilla Parishad on 18/9/21. For the interest of public, I would like to withdraw my resignation from the post of President of Jilla Parishad, Karimganj Jilla Parishad, 2/10/21. My lord, on this, the learned single judge has not recorded any finding. But on page 80, no, 86. Page 40. So, now, my lord, sorry, please come to page 48, my lord. Actually, same document, it appears in two different places. Instead of, my lord, page 82, if your lordship kindly takes note of page 45, where this letter dated 2/10/21 appears. Instead of 82, lordship will kindly take note of page 45. Same letter, my lord. One as a part of the writ petition and other one as a part of the another writ petition. Yes. Now, please come to page number 47. Kindly see, my lord, Ashish Nath, scene delivered on 2nd October 11:54 AM. Has your lordship noticed that, my lord? Yes. Please come to 48. Forwarded from Ashish Nath, date 2nd October 21, 12:35 PM. Subject withdrawal of resignation from the post of President Jilla Parishad to pnrddispur@gmail.com as the website of the government. So there is no dispute that on 2nd itself, my lord, the copy which was addressed to the Deputy Commissioner was forwarded to the, my lord, government. Now, for a moment, lordship will kindly take the act, Panchayat Act. Now, let us test the argument of the state. Section 72. A member holding the office as president of Jilla Parishad may resign his office at any time by writing and sending it to the government through Deputy Commissioner, and Vice President of Jilla Parishad may resign his office at any time by writing and sending to the President of the Jilla Parishad, and in the absence of the President, to the government through Deputy Commissioner. An office shall become vacant on the expiry of 15 days from the date of such resignation, unless within the said period of 15 days, he withdraws such resignation by writing and sending it to the government. Now here, my lord, a meaning is sought to be given by the learned Advocate General that the resignation letter has to be addressed to the government. And it has to be sent directly to the government. These are the purport of my learned friend's argument, my. Now, Lordship knows if legislature does not use a certain specific expression, then it is presumed the legislature deliberately did not do so. First, my lord, Lordship do not find the expression directly to the government. Secondly, my lord, when it comes to, my lord, sending the, resignation, my lord, to the government through Deputy Commissioner. So here, specific instances has been given. In the later part, a general expression has been used. Therefore, in this situation, my lord.
Let us read it again.
Yes. May I read it from the very beginning? A member holding the office as president of Jila Parishad may resign his office at any time by writing and sending it to the government through the Deputy Commissioner. Let us not read the later portion, my. Then, and the office shall become vacant on expiry of 15 days from the date of such resignation. So let us stop it for a while, my lord. That means the manner which has been prescribed for resignation is that it has to be sent to the government through the Deputy Commissioner. The moment it is done, on expiry of 15 days thereof, the office stands vacated. Now, when it comes to withdrawal, my lord, those specific words are not used, but general words are used. This is where, my lord, the principle of Iusdem generis applies. Where general words are preceded by specific words, my lord, the meaning of those specific words are to be given in the general words. That is what in law we call, my lord, in administrative law we say, principle of Iusdem generis. Now the genus is XYZ, and when we speak precisely, then it is the, my lord, specie. So in this case, there is no dispute that the resignation was sent to government and withdrawal was also sent to government through the Deputy Commissioner. There is no dispute. In fact, they have admitted. Now, I'll come to little later on this aspect, my lord. Let me place two documents, then I'll come to it. Please come to page number, my lord, 86 or page 49. This is a document by Deputy Commissioner to the Chief Executive Officer of the Jila Parishad. With reference to the subject cited above, I would like to apprise that one withdrawal letter submitted by Ashish Nath, President Jila Parishad Karimganj, in connection with his resignation letter submitted on 18/9, which was forwarded to the Principal Secretary to the Government of Assam Panchayat and Rural Development, by this letter dated so and so. It may be mentioned that aforesaid withdrawal letter is received on 4/2/21. After expiry of statute, that is his interpretation. But factually, he admits that this letter was received on 4th. So I have already indicated, my lord, by application of section 10 of the General Clauses Act, it was within time. All these aspects were taken note of by the learned single judge. I'll place it. Though, my lord, he says after the expiry of 15 days, that is his understanding, which is not correct. So it's clearly admitted. Now, my lord, will kindly come to page number 91. Sorry, page 94. This is again a communication by Deputy Commissioner to the government. 94. 94. Further, first para, my lord, the withdrawal letter received by undersigned on 4/10/21 after expiry of statutory period of 15 days from the date of resignation, date is so and so, from the office of so and so so and so. So on two places, the Deputy Commissioner clearly admits that the resignation withdrawal letter was received on 4/10/2021. That is, which is within time. Therefore, to say that this was beyond time is absolutely incorrect. Now, please come to page 91. This is 11th October 21. This triggered the second writ petition, my lord. With reference to your letter on the subject cited above, I have the honor to inform you that resignation of Ashish Nath, President, Karimganj Jilla Parishad is hereby accepted as per section 72(1) of the Panchayat Act. This has approval of the Honorable Minister. Now, if you have not received a withdrawal which is not informed, what was the corresponding obligation on your part to accept it? By accepting, you have given legitimacy to my withdrawal letter, my. That is already admitted. So the argument of the state that it was not addressed to the state government, Allah doesn't hold any water. You can't blow hot and cold. Your argument is this is not informed. If this is not informed, this is non-est. That means if there was a legal requirement that you have waived by your misconduct, here, my lord, there is a conscious, waiver on the part of the state. The moment you say that you have accepted the resignation, assuming there was a requirement, that means you have waived it. Now, my lord, will kindly come to paragraph 8 of the affidavit at page 97. What I am trying to show are all undisputed facts. Please come to last 5 lines, sentence starting with further on page 97. Further, so far sending of the aforesaid letter dated 2/10/21 in the official website of the department on 2/10/21 is concerned, the said day was a holiday being Gandhi Jayanti and 3/10/21 a Sunday, hence the said letter was received after resumption of the normal office hours. That means on 4th. Department further received signed copy of the document forwarded by the Deputy Commissioner. I know that is our internal communication. So, my lord, the stand of the state is the withdrawal letter which was sent on the website, it was recorded in the website on 2nd, but 2nd and 3rd being holiday, they acknowledge that they received it on 4th. And this is the government's affidavit, my lord. So, my lord, there is no dispute that withdrawal of resignation was within time. Now, my lord, another aspect which I think your lordship will have to take note of. When a mandatory prescription is made by statute, your lordship has always held that there has to be a substantial compliance. But when it comes to procedural part, your lordships always insist on a liberal construction, not a strict construction. And my lord, a literal meaning is not given. Now that the withdrawal letter has to be sent to the government in a particular manner, it is a procedure. The purpose is served the moment withdrawal letter is received by the government, as has been admitted by the Principal Secretary in his affidavit at Para. He admits that on 4th he received it. That's why he accepted it on 11/10. So now it does not lie in the mouth of the state that it was not in accordance with law. Well, I'll place one judgment on that point. এখন দিয়ক না। Please come to para 6, my lord. This was also regarding imposition of a tax. The argument was the notification was not informed, therefore the benefit cannot be derived by the state. Para 6. In the present appeal, however, only 2 points have been asked before us on behalf of the appellant. We are therefore not concerned with the other points raised in the High Court and shall confine ourselves to the 2 points asked before us, namely, there was no publication as provided by section 131(3), read with section 94(3) of the Act, and as the provision of section 131(3) is mandatory and was not complied with, all subsequent action taken for imposition of tax was bad for non-compliance with the mandatory provision, and therefore tax itself was not levied according to law and could not be realized. So this was the contention, my lord. Now, my lord will kindly come to paragraph 11. I think I should read para 11. Turning now to the second part, which provides for the manner of publication. That manner is provided in section 94(3) already set out above. It seems to us that when legislature provided for the manner of publication, it did not intend that the manner should be mandatory. So long as publication is made in substantial compliance with the manner provided in section 94, that would serve the purpose of mandatory part of section, which provides for publication. So as long as there is publication, and in this case, as long as it is sent, enough, suffice. In this connection, we may refer to so-and-so versus so-and-so. In that case, a question arose whether section 117 of the Representation of the People's Act was mandatory or directory. That section required that a petitioner filing an election petition had to enclose with his petition a government treasury receipt showing a deposit of 1,000 rupees had been made by him either in government treasury or in Reserve Bank of India in favor of Secretary to the Election Commission as security for the cost of the petition. This court analyzed this provision and observed that it consisted of 3 parts, namely, government treasury receipt must show that such receipt has been actually made in the government treasury or in the Reserve Bank of India. It must also show that it had been made in favor of Secretary to the Election Commission of India. It must further show that it had been made as a security for the cost of the petition. The question then arose whether the words in favor of Secretary to the Election Commission were mandatory in character, so that if the deposit had not been made in favor of Secretary to the Election Commission, as therein specified, the deposit, even though made in the government treasury or in Reserve Bank as a security for the cost of petition, would be invalid or of no avail. This court held that the words in section 117 were directory and not mandatory in their character, and that essence of the provision contained in section 117 was that the petitioner should furnish security for the cost of the petition and should enclose along with the petition a government treasury receipt showing that the deposit of 1,000 rupees had been made by him either in a government treasury or in Reserve Bank of India to be at the disposal of the Election Commission, to be payable on a proper application being made in that behalf to the Election Commission or to any person duly authorized by it to receive the same, be he the requirement, be he the Secretary to the Commission or anyone else. If this essential requirement was complied with, no literal compliance was at all necessary with the words in favor of Secretary to the Election Commission appearing in that section. Though therefore the making of deposit and presentation of receipt thereof along with petition was held to be mandatory, this court held therefore the form in which deposits should be made was only directory. The principle of that case, in our opinion, applies to the manner of publication provided in section 94(3) in the present case. As we have said already, the essence of section 131(3) is that there should be publication of the proposal and draft rules so that taxpayers have an opportunity of objecting to them, and that is provided in what we have called for the first part of section 131(3). So, my lord, here that money should have been paid pledging in favor of Secretary to the Election Commission. It was not done. Supreme Court says as long as money is given in the Treasury or in the Reserve Bank of India to be payable to Election Commission is enough. What is the requirement here, my lord? To be sent. It has been sent. It has been received. It has been acted upon. So therefore, my lord, when it comes to compliance with a procedural requirement, it has been the consistent view of the Honorable Apex Court that always do not apply strict construction. Always apply a liberal construction. As long as, my lord, the substantial compliance of that withdrawal is received by the government. End of the matter. So, my lord, what is wrong in the view of the learned single judge? Now, please come to para 19 of the judgment. Judgment to page judgment. Yes. My lord will first come to page 130. Paragraph yes. Please come to 142 first, my lord. 6.2, it was one of our contention. At 142, para 6.2. It is his further submission that with the 2nd of October being a holiday and 3rd day of October being a Sunday, the last day of 15 days period had to be taken as 4/10/21 in view of the provisions contained in so and so. He has pointed out, respondent was admitted in his letter dated so and so that he received the letter of withdrawal of resignation from the petition on 4/10/21 and forwarded to the same to the government by his letter dated so and so. So, my lord, this is our submission. Then kindly come to para 19. Sorry, 19.1 at page 151. By sending the letter of withdrawal of resignation to the email account of the government in the Panchayat and Rural Development Department, petitioner had taken the requisite step as may be reasonably required on his part to inform about his intention to withdraw his earlier letter of resignation to the government in the ordinary course within 15 days time period. And it is another matter whether or not of the fact of such withdrawal of resignation had actually been known or not known to the government within 15 days time period. Because the act of withdrawal of resignation being so also of unilateral character, the condition laid down in section 72(1) of the act is fulfilled when holder of the office of the president of Jilla Parishad takes the necessary steps for sending the letter of withdrawal of resignation within the stipulated time period by ensuring that it reaches at the proper destination, that is the government, in course of time. The court is also not oblivious of the proposition that a provision relating to giving or sending of a notice call for a liberal interpretation for the person who has the statutory obligation of sending a notice because he is presumed to be a loser in the process and it is for the safeguard of his interest, the very provision has been incorporated in the statute. Absolutely correct in my humble submission. In the case in hand, the petitioner had been seen to have performed the act of sending the letter of withdrawal of resignation to the government within 15 days from the date of submission of the earlier letter of resignation on 18/1 by sending the email to the email account of the government at 12:35 p.m. on 2/10/21. Email was sent under the subject withdrawal of resignation from the post of so-and-so. From the discussion made above, it is already found that time period available at the petitioner's disposal to withdraw his resignation letter was up to 4/10/21, and petitioner had performed the act of withdrawal of resignation within the stipulated time period. Though a question with regard to admissibility of the letter of withdrawal of resignation sent by email on so-and-so has been read, but acknowledgement of receipt of the signed copy of said letter at a later date by the respondent number 1 in his affidavit has substantiated the fact of sending the letter of withdrawal of resignation by the petitioner in the stipulated period of 15 days. Thus, decision rendered by the departmental counsel on admissibility or otherwise appear to be of no relevance for the case in hand. In such view of the matter, this court is of the considered view that office of the president of Karimganj Jilla Parishad did not cease to have been vacated by the petitioner at any point of time, contrary to the view held by the state respondent. So what is wrong in it, my lord? It's absolutely in tune with the scheme of the act. Anyway, my lord, I'll take 5 minutes at 2 o'clock.
My reply may be given tomorrow, Lordship. I have to go for a meeting in the second half. My reply will be tomorrow.
But it took adjournment for the timing. Now they are saying that it will not be possible for today. Can it be on 1st of February, my lord? Because at their convenience, my lord, I have to.
Lordship,
It's a 19 matter, 2019 matter, though it has been registered as 21 matter, 21. Item
I think
14, lordship. Of today's list.
Okay. Joint prayer.
No, not my prayer, my lord. It was
Okay,
her prayer.
On request made by Ms. LDB, Leonard CEC, based on 1st February.
apply.
Extremely sorry, my
Lord, I was referring to the operative para of the June judgment, where the learned single judge, my lord, after referring to the facts and appreciating the legal principles, have come to the right find. So, my lord, in this case, it looks like there is no dispute that within 15 days' time, be it second, be it fourth, my lord, it reached the government accepted it, government acted on. It's a different matter. It is their perception or their misconception that they think that it is beyond 15 days' time. Their lordships will take a call. But on facts, that it was filed either on 2nd or 4th, that is not in this. So it was within 15. Now, my lord, I'll rely upon one judgment of the Supreme Court on this point. Normally, my lord, when a writ appeal or a intra-court appeal is preferred, what is the scope on that, my lord? 2016 3 SCC 340. One small paragraph, para 5. 2016 3 SCC 340.
What is the party name?
Party's name is, my lord, Management of Narendra Company Private Limited versus Workmen. Para 5. Once the learned single judge, having seen the records, had come to the conclusion that industry was not functioning after January 1995, there is no justification in entering a different finding without any further material before the division bench. The appellate bench ought to have noticed that statement of MW3 is itself part of the evidence before the labor court. Be that as it may, now this is important. In an intra-court appeal on a finding of fact, unless the appellate bench reaches a conclusion that the finding of the single bench is perverse, it shall not disturb the same. Merely because another view or a better view is possible there should be no interference with or disturbance of the order passed by the learned single judge, unless both sides agree for a fairer approach on relief itself. So, my lord, the view taken by the learned single judge that the letter of withdrawal having reached the government on 2nd or 4th, as the case may be, there's nothing perverse in it, my lord. There's nothing perverse. So therefore, the learned single judge was correct, and lordships will not, merely because another better view is sought to be projected, that by itself is not a ground to invoke the powers of intra-court appeal. On the contrary, my lord, kindly see the prejudice which has been caused to the writ petitioner respondent. Though I'm an elected man, my lord, I'm not at the mercy of anybody. I'm an elected person in a democratic system. So it will be to my prejudice. In fact, my lord, the first meeting of this Karimganj Jilla Parishad was held on February. So, my lord, the election would be declared anytime after first week of February. Therefore, my humble submission is, my lord, lordships will dismiss the appeal because it lacks any merit. And, my lord, the consequential direction should go in terms of the order of the learned single judge. That is my humble submission, my lord. Otherwise, I'll be only multiplying or repeating the same thing.
What do you say on the first letter? First of October 2021.
Yes, I'm relying on it, my lord. 1st October letter at page number 81, Nikki. Yes. Oh, it was addressed to the principal secretary. Oh, that's what I said, my lord. I think I invoke that principle of uses them generis only on that. End of the day, my lord, idea is this withdrawal or resignation, it has to reach the government. How it reaches is not very material.
No, how did you send it?
This one.
Ah.
One second, man.
That is page 44.
Yes. Page 29, my lord. It is stated that on 1/10/21, the petitioner submitted a communication for withdrawal of his resignation later dated 18/9/21 due to public demand as well as a request from the members of Karimganj Jilla Parishad before Principal Secretary to the Government of Assam Panchayat and Rural Development, with a prayer to allow him to continue as president and to take necessary steps as per provision. In any case, my lord, learned single judge has not taken cognizance of this letter. Learned single judge has not taken note of this, because in the view of the learned single judge, my lord, maybe, my lord, enough materials we could not place before the single judge, in support of it. Learned single judge has not taken note of it. On the contrary, my lord, the 210 at page 82, that is the letter which was relied upon by the learned single judge. I think the single judge has recorded that. What question? Page 82, my lord. This is the letter which was acted upon. No, this also. My lord, this 110 letter, it was not taken note of by the learned single judge. If your lordship would kindly come to page 4.1 of the impinged judgment at page 131. Page 139. Para 4.1. The petitioner has claimed that he submitted a letter on 1/10/21 to the respondent number 1, withdrawing his letter of resignation from the office of the President, Karimganj Jilla Parishad, submitted earlier on 18/9/21 before respondent number 3, owing to demands from the public as well as from members of Jilla Parishad. By the said letter, petitioner stated to have requested respondent number 1 to take necessary steps as per provisions of section 72(1). So, my lord, learned single judge also dealt with this later. I'll just place that para. No, except for. Just give me 1 minute time. Okay. 6 point. Oh, 6 नहीं है नहीं है my lord will kindly come to para 6, my lord, of the impugned judgment. Para 6. The sentence starting with Mr. Talukdar.
You have para 6? Huh? We don't have para 6 here.
In the other memo of appeal, lordships will get it, my lord.
Eight is in fact missing.
In fact, that is what I find. It's filed by the state, my lord. There is 2 appeals. If your lordships would kindly have the paper book of the other appeal. At page 137. A lordship is correct. Even in my paper, maybe 1 page was inadvertently left out.
Yes.
Has your lordships got it, my lord? Yes. Mr. Talukdar learned, no, lordship will kindly take the 5th line from bottom, even if it is assumed. Has your lordship got it? At para 6, 5th line from bottom. Even if it is assumed that a letter of withdrawal of resignation was not submitted in proper manner on 1/10/21, petitioner had forwarded his letter of withdrawal of resignation to respondent number 3 through WhatsApp message on 2/10/21 and also send the email in the website of Panchayat on 2/10/21 intimating his withdrawal of resignation from the post of president of Jila Parishad. So Lanet Singhal Judge has dealt with it, my lord. In other words, Lanet Singhal Judge has not taken cognizance of 1/10. So nothing hinges on 1/10. It's not that, my lord, we are claiming any. In fact, I have not placed this letter also. We are saying second, because since Lanet Singhal Judge has not accepted it, therefore no point arguing based on 1/10/21 later. So it is 2/10/21, my lord, which is important in our humble submission. So for the necessary ingredient of section 72 is, my lord, if within 15 days the resignation is withdrawn, then, my lord, it stands withdrawn. It will not be effective. Kindly have a look at section 72. Now, there is no requirement of any acceptance. A member holding the office as president of Jila Parishad may resign his office at any time by writing and sending it to the government through the deputy commissioner. And the office shall become vacant. I am not reading the in-between portion on expiry of 15 days from the date of such resignation, unless within the said period of 15 days he withdraws his resignation by writing and sending it to the government in respect of the president and to the president in respect of the vice president. So requirement envisaged by section 72(1) is, otherwise within 15 days it will take effect. But in the meantime, if within the period of 15 days it is withdrawn, then it will not take effect. And there is no requirement of any acceptance, my lord. It's a deeming provision. In that view of the matter, my lord, I don't think there is anything wrong in the view of the Lanet Singhal Judge, which calls for your lordship's interference in this exercise of intra-court appeal powers. That is my submission.
Okay, but Mr. D. Saike, Learned Advocate General, Assam, for the appellants. Assisted by?
Yes, doctor.
Yes, Doctor. Learned Counsel for the applicants. Also heard Mr. K. N. Chowdhury, learned senior counsel, assisted by
SK Talukdar.
S.K. Talukdar, learned counsel. For the
Respondent
One.
number one, writ petitioner.
oblique with petitioner, heard in part. Please forfeit the hearing. Tomorrow, he said, isn't it?
I
Yes,
think my learned friend wants to give his reply.
tomorrow. Tomorrow is what date?
Wednesday, my lord. Tomorrow will be in 10.
10.
My lord, item number 15 and 16 is kept for the time being. Can I pray item number 16 may be taken, my lord? And item 15, with the lordship's kind permission, can I do it on Thursday, my lord? There is also some urgency there. Day after tomorrow, my lord.
On 15,
Yes. No, on my lord, 11.
11. Okay.
15, 16 I'll do now, my lord.
Item 15, I'm requesting by K. N. Chowdhury. And then senior counsel for the applicant. List on
11th, my lord.
11th. All right.
My lord, item 19, my personal matter, my lord. If it can be taken, I've come only for this case, my lord.
We are going serial wise. You wait for your turn.
Sorry, my lord.
We are going serial turn.
Yes, serial, my lord.
Yeah.
Next serial, my lord.
No. Just item 16. Item 16.
Now 16 is being called.
Item 16.
My lord, in this matter, certain issues of huge, my lord, constitutional implication arises. Now, what had happened, my lord, lordship knows Government of India entered into an memorandum of understanding with Boro Liberation Tigers, my lord, an organization which was initially fighting for, my lord, separate homeland. And eventually, my lord, it culminated into that Bodoland Territorial Council area. Now, my lord, what we'll be projecting before lordships in this proceeding is how, my lord, over a period of time, the ultimate objective of devolution of power has been compromised. My lord, a sixth schedule, my lord, this area was included. The idea was it will be a state within the state. Now, by subsequent, my lord, some understanding how, my lord, gradually the power has been, my lord, diluted. That is what will be. If a lordship would kindly come to page number, my lord.
It is not fine.
First, go ahead.
All parties are represented.
Yes. Good night. 2293 to quote asile page. 293. Page
130.
Ah.
22, 19, and
First Bodo Accord.
Just a minute.
Yes.
Union
of India.
Assam Chief Secretary. You are appearing.
Yes.
Then respondent 3, you're also there. Rabah.
ETC.
First record. First record from court.
WBD and BC.
It was a 130.
Home and political.
Otherwise, states are represented, my lord. Only Union of India, I think somebody can automatically have.
One respondent is missing. WBT.
They're all represented by the state, my lord.
Are you representing?
No.
That was standing for.
Wait, Diana.
You are pretty? On behalf of
On
our.
behalf of Mr. R.
Yes. My lord, on 20 February 1993, the first Bodo Accord was signed between Union of India, State of Assam, All Bodo Students Union, and Bodo People Actions Committee.
Date?
1993. First Bodo Accord, my lord. My lord, the basic objective of the accord was to provide maximum autonomy to the boroughs for social, economic, educational, ethnic, cultural advancement. This was the basic idea, underlying idea. In other words, my lord, devolution of power for self-rule. Now, my lord, it was followed by the second Bodo Accord, which your lordships will get at page 131. On 10th of February 2003. In fact, my lord, the concept of the sixth schedule, thing came only after this.
This is the second accord.
Yes. Memorandum of Settlement on Bodoland Territorial Council. 10th of February 2003. The government of India and government of Assam have been making Government of India and Government of Assam have been making concerted effort to fulfill the aspirations of the Bodo people relating to their cultural identity, language, education, and economic development. Towards this end, a series of talks were held between Government of India, Government of Assam, and Bodo Liberation Tigers since 2000, March 2000. As a result, it is agreed to create a self-governing body for Bodo areas in the state of Assam as follows. The objective of the agreement are to create an autonomous self-governing body to be known as Bodoland Territorial Council within the state of Assam and to provide constitutional protection under sixth schedule to the said autonomous body to fulfill economic, educational, linguistic aspirations and the preservation of land rights, socio-cultural and ethnic identity of the Bodos, and to speed up the infrastructure development in the BTC area. The area of the proposed BTC shall comprise of all the 3,082 villages and areas to be so notified by the state government. The above mentioned villages and areas shall be divided into 4 contiguous districts after reorganization of the existing district of Assam within a period of 6 months of signing of the agreement on the lines of the proposal given by BLT subject to clearance of the Delimitation Commission. A committee comprising of 1 representative each from Government of India, Assam, and BLT will decide by consensus on inclusion of additional villages and areas in BTC from out of 95 villages and areas on the basis of criteria of tribal population being not less than 50%, contiguity, or any other agreed relevant criteria within a period of 3 months of signing of this signing of this MOS. Now, the basic idea was, my lord, in addition to these 3,082 villages, there are about 95 villages out of which where the tribal population is not less than 50%, those will also be included. That was the underlying idea. Now I'll show, my lord, how this, provisions are being diluted. Now please come to 132, my lord, next page. Powers and functions. 5.1 towards the bottom. The council shall have legislative powers in respect of subjects transferred to it as enumerated below. All laws made under this paragraph shall be submitted forthwith to the governor and then until assented to by him shall have no effect. The BTC shall have executive, administrative and financial powers in respect of the subjects transferred to it. Then my lord, next page. Subjects to be entrusted to BTC by Assam government. So these are the whole lot of all subjects, my lord. And in respect of subjects which are being transferred to BTC, Assam government will not exercise any power. It's a state within the state. Then my lord will kindly come to page 138, how the constitution was amended. Hmm? 5.3. If I may be permitted to read 5.3 also, my lord, at page 133. The BTC shall have full control over the officers and staff connected with the delegated subjects working in BTC area and shall be competent to transfer officers and staff within the BTC area. ACR of these officers shall be written by the appropriate BTC authority. So, my lord, once an officer is transferred, his controlling authority will be the BTC, including, my lord, disciplinary proceedings. Then, my lord, will kindly come to page 138. Now, this is the statement of objection reasons of the Constitution Amendment Bill, my lord. The provisions of the sixth schedule to the Constitution have evolved a separate scheme for governance of the tribal areas in the state of Assam, Meghalaya, Mizoram, Tripura, to district councils or regional councils. There are 3 parts in the table appended to the schedule. They are so divided in order to distinguish the areas. Areas in part 1 represent tribal areas of Assam. Each of these areas constitute an autonomous district. The provisions in paragraph 1 to 17 of the 6th schedule relate to administration of these autonomous districts. Councils are vested with legislative power on specified subject and are allotted source of taxation. They have also been given power to set up and administer their system of justice, maintain administrative and welfare services in respect of land, revenue, forest, education, public health, etc. The Bodo Accord was signed on February 20, 1993 with All Assam Bodo Students Union and Bodo People's Action Committee with the objective to provide maximum autonomy to the Bodos within the framework of the Constitution for their social, economic, educational, and cultural advancement. In pursuance to the Bodo Accord, an interim Bodo Autonomous Council was constituted by Government of Assam by enacting the state legislation. Bodo groups were of the view that Bodo Accord has become unworkable due to non-implementation of the accord in letter and spirit. Based on tripartite talks, a memorandum of settlement has been signed between the central government, Government of Assam and BLT on 10/2/23 for a durable solution to the Bodo issue. To meet the aspirations of the Bodos in Assam and in pursuance of the MOS, it is proposed to create an autonomous self-governing body to be known as the Bodoland Territorial Council within the state of Assam, which shall have legislative, administrative, financial power in respect of the specified subjects. Provide for adequate safeguards for non-tribal in the BTC area to ensure that they are not put to any disadvantage in relation to any rights and privilege, including land rights presently enjoyed by them at the commencement of the BTC. So, my lord, the idea was devolution of power in respect of these transferred subjects. It will be a state within the state. Then, my lord, will kindly come to page 140, my lord, the relevant constitutional amendments. My lord will kindly come to page 141. I'll have your lordship's kind attention to paragraph 3, my lord, para 3. In para 2, in sub-para 3, after the proviso, the following proviso shall be inserted. Provided further that district council constituted for Bodoland Territorial Area District shall be called BTC, Bodoland Territorial Council. Now this name is also sought to be changed, my lord, by an executive order. Unheard of, my lord. Please come to para 5. After paragraph 3A, the following paragraph shall be inserted, namely, additional power of Bodoland Territorial Council to make laws. So these are the, my lord, different powers with regard to lawmaking, which has been given to my lord. 38. There are 38 subjects, my lord, in all. Now please come to page 145. Because the amendment, my lord, the sanctity of the MOS, lordships will get here. Page 145. For the purposes of this subparagraph, the expression memorandum of settlement means memorandum signed on 10th day of February 2003 between Government of India, Government of Assam and Bodo Liberation Tigers. The second Bodo Accord at page 131, my lord, which we have demonstrated, my lord. Now that has been taken note of. In fact, that was the basis for the constitutional amendment. And in the constitutional amendment itself, it takes note of the MOS. So thereby, my lord, putting it on a much higher pedestal to be tinkered with at a later stage by some executive fiat. Then my lord will kindly come to page number 149. Sorry, my lord, 146. In fact, my lord, subject will transfer koi dile na. 146, my lord. MOS. No, amendment to kwana yet. That date to kiman asile heavy. Again, ekon hold was September or ekon hold. Oh, yes. Page 146, my lord. My lord, pursuant to the MOS and the constitutional amendment, this was an office memorandum which was issued by the Assam government. Whereas in pursuance of memorandum of settlement reached between Government of Assam, Government of India and BTC on, Bodo Liberation Tigers on 10th of February 2003 in New Delhi, in presence of Deputy Prime Minister of India, it has been agreed to create Bodoland Territorial Council within the framework of the amended 6th schedule of the Constitution of India. And whereas Government of Assam by notification dated 31st of October 2003 adopted and approved the aforesaid MOS and resolved to extend executive powers to 40 subjects, department listed in Annex 3. Whereas Governor of Assam has been pleased to entrust and delegate functions relating to 39 subjects departments listed in para 3B of the 6th schedule of the Constitution of India and to which executive power of the state extends. Now, therefore, the following administrative procedure and modalities are framed by the state government in consultation with Bodoland Territorial Council for the purpose of day-to-day administration in respect of the 39 subjects. So, my lord, pursuant to the MOS and the constitutional amendment, this office memorandum was issued by the state government, whereby, my lord, the power was transferred by. Now, I'll have your lordship's kind attention to page 150, my lord. 139, oh yes, 149, my lord, yes. G and H. The BTC shall have full control over the officers and staff connected with the entrusted subjects working in the BTC area and shall be competent to transfer these officers and staff within BTC area. ACR of these officers shall also be written by the appropriate BTC authority. BTC shall be competent to make appointment on all posts under its control in accordance with the rules of appointment followed prescribed by the government of Assam. The council shall constitute a selection board for etc. etc. Then my lord will kindly come to page 150, clause J. The state government shall consult the council while posting, transferring officers of entrusted subject department in or out of the council. The officers and staff not released by council shall normally not be accepted by the state government. So state government, my lord, without the concurrence of the council, my lord, perhaps cannot do anything. Now L is very important, my lord. Financial power, legislative power. L at page 151. The Bodoland Territorial Council shall prepare the estimate of receipt and expenditure pertaining to Bodoland Territorial Council in respect of the entrusted subjects department as per the allocation norms communicated by the state government. The Bodoland Territorial Council in their council session shall consider estimated, that means the budget. This is regarding budget. Then my lord will kindly come to M at page 152. The Bodoland Territorial Council Authority shall prepare a plan with amounts likely to be made available for development works, both under the state share and central share, covering any or all activities of the department under their control. The council shall have full discretion in selecting the activities and choosing the amount for investment under the same in any year. This plan will be a subset of state plan and would be treated as integral part. Once plan of the state, including BTC plan, gets the approval of the planning commission, the BTC authorities shall start execution of the plan in BTC area. Modification, if any, made by the planning commission in BTC proposal shall be binding on BTC. BTC shall have a planning department to prepare plans, just like any state government. So, my lord, in substance, this memorandum recognizes, my lord, N is also important at 152, my lord. All centrally sponsored schemes, central sector schemes, NEC schemes, externally aided schemes, etc., in respect of the entrusted subjects for its fund will be released by the state government to the council as per sanction and released by Government of India to state government shall be implemented by the council as per norms and guidelines of the Government of India and the state government. The BTC next, O, will exercise its legislative power as conferred under clause 3B. The delegation of executive power in respect of relief, etc., etc. So, my lord, in entirety, in respect of the transferred subject, it is the prerogative of the Bodoland Territorial Council, just like any other state or an union territory. Now, my lord will kindly come to the impugned accord at page 155. The Government of India and Government of Assam have been making concerted efforts to fulfill the political, economic, social, cultural, and identity-related aspirations of the Bodo people. Tripartite agreements in 93 and 2003 were signed, leading to creation of Bodoland Autonomous and Bodoland Territorial Council under the 6th schedule to the Constitution for Bodo inhabited areas in Assam. APSU and its associated organizations as well as various factions of NDFB continued with the demand for separate statehood. Negotiations were held with the Bodo organization for a comprehensive and final solution to their demand while keeping intact the territorial integrity of the state of Assam. Objective of the MOS: to augment area and powers of BTC and streamlining its functions. To address issues relating to Boros residing outside BTAD, to promote and protect social, cultural, linguistic, and ethnic identities of the Boros, to provide legislative safeguard for the land rights for tribal, to ensure accelerated development of tribal areas, and to rehabilitate members of NDFB faction. My lord, we all understand the literal meaning of the expression augment. We also understand, my lord, the literal meaning of the expression power. Something exists, something is existing that needs to be augmented. Not to, my lord, curtail, not to constrict, not to reduce. Now, I'll demonstrate, my lord, though the expression augment has been used, in effect, my lord, this memorandum of settlement, which is under challenge, in reality, my lord, it takes away the devolution of power. Very unfortunate, and that too by an executive order. And you see, my lord, second MOS, based on that, there is a constitutional amendment. It's not an ordinary law. It's not an ordinary parliamentary legislation. It's a constitutional amendment. That means under 368. Now, my lord, that is sought to be tinkered with. Just see how it is being done, my lord. So therefore, this expression augment is absolutely a misnomer, my lord. Commission will be appointed under para 14 of the 6th schedule to the Constitution soon after signing of MOS to examine and recommend on the following: inclusion of villages contiguous to BTAD and having majority tribal population as demanded by the Boro organization. Exclusion of villages currently under BTAD, which are contiguous to non-6th schedule areas and have majority non-tribal population. Increase in the constituencies of BTC up to 60 seats after alteration in the area without adversely affecting the existing percentage of reservation for tribal. The commission will include, anyway, my lord, we appreciate, my lord, this Roman 3.2. Please come to, my lord, the first accord, second accord at page 131 for a moment. Please come to 131, my lord, 3.1. Area of proposed BTC shall comprise of all 3082 villages and areas to be so notified by the state government. That means 3082 villages are included. In addition to that, in terms of 3.2, my lord, there were about left out 95 villages where the total tribal population is not below 50%. Those will also be endeavored to be included in the BTC. Now, on the contrary, now what is now is attempted, my lord? Exclusion of villages currently under BTAD, which are contiguous to non-6th schedule areas and a majority non-tribal population. It is in direct conflict with clause 3.1 and 3.2 of the MOS, and which is, my lord, already, my lord, taken note of by the Constitution Amendment itself. This is one. Commission will include representative of the state government as well as other stakeholders, including ABSU and BTC as its member. It will submit its recommendation within 6 months from the date of notification. The existing Bororel Territorial Area District shall be renamed as Bororel Territorial Region, comprising areas covered under BTAD. How can this be done, my lord? Unless you amend the Constitution. Government of Assam may consider reorganizing the districts consequent to an alteration of the area of BTAD on administrative consideration And my lord, reorganization of district is a separate thing without, encroaching upon the powers of the PTC. Now, kindly come to this review of powers and functions of BTC. Continue important, sir. Kindly see, my lord, 4.1. The process of BTC to have more legislative, executive, administrative, and financial power in in respect of additional subjects as enumerated in Annexure 1 will be initiated within 90 days. That means they want to augment the, my lord, the existing system. Then please come to 4.4. Executive function of BTC shall be through its chief executive officer, not below the rank of principal secretary. Senior-most officers of various departments shall be not below the rank. All right, these are nothing objectionable. Yes. Please come to 158, my lord. Seven is okay, provided if it is implemented, my lord. We have no quarrel with 7. 8. Government of Assam will create a separate department to deal with matters relating to council under the 6th schedule of the constitution, including BTC. Now, my lord, they have already set up a department, or rather reconstituted a department to look after the affairs of the BTC. Yes. And there are, I think, 2 more district councils under the state of Assam, my lord. One is Karbi Anglong, other is Dima Hasao, where a similar exercise has not been carried out. There, my lord, ever since the constitutional amendment they were incorporated, my lord, never it has been tinkered with, unlike in the case of the Bodoland territorial area. Now, my lord, will kindly come to page 174. It is a notification of September 28, 2020. In exercise of the power conferred by clauses FF of subparagraph 3 of para 1 of the 6th schedule to the Constitution of India, the governor of Assam is pleased to alter the name of Bodoland Territorial Area District as specified in part 1 of the table appended to so-and-so to Bodoland Territorial Region. All right, so far so good. Now, my lord, will kindly come to page 175. In pursuance of clause 3.1 of the Memorandum of Settlement signed on 27th of January 2020 by the Government of India, Government of Assam, All Bodo Students Union, NDFB, the Governor of Assam is pleased to constitute a commission under paragraph 14 of the 6th schedule to the Constitution of India with the following members for alteration of the area of BTAD. Now, this gentleman called, my lord, P.P. Verma, I think he is no longer there. Now, he has been substituted by one Mr. Ashish Bhutani as chairman. Sign number 2. Kindly see, my lord, serial number 41, Dalim Bayon, convener, Red Cross, Udalguri. I don't know, my lord, how he has been included, my lord. He appears to be a stranger, my lord, to the entire scheme of things. I can appreciate, my lord, All Bodo Students Union, Joint Secretary, Home and Political, but convener, Red Cross. Now, my lord, what is most important is petitioner number P3 to 9 are signatories to the original Bodo Accord. Yes, page 2. Now, my lord, to appreciate what I have submitted, that this gentleman called Dalim Bayon is not a relevant, person, my lord. Please come to page 155, 3.2. Kindly see, my lord, is very specific. The commission will include representatives of the state government as well as other stakeholders, including so and so. My lord, when we say stakeholder, what we mean? The organizations which have spearheaded the movement, they are the stakeholders. For example, All Boro Students Union, Bodoland People's Action Committee, NDFB, these were the organizations which were fighting for autonomy of the Bodoland. So they are the stakeholders. But who is this gentleman called Dalim Bayon? What business he has got, my lord? My lord, this can't be the Ipsy Dixit of the state government. End of the day, it's a constitutional scheme. In the constitutional scheme, if you want to give power to somebody, then it must be prescribed. This power cannot be derived from thin air. So therefore, my lord, our second submission would be this inclusion of this Dalim Bayon in the committee is absolutely without any authority. And he is not a stakeholder, neither he belongs to any state government. Then my lord will kindly come to page number 199. Can I go to 198 plus? Sorry. 199, my lord. In pursuance of the transferred subject vested with Bodoland Territorial Council by 6th schedule to the Constitution of India and a notification dated 19th of January 21 issued by Personnel Department, Government of Assam, relating to implementation of Memorandum of Settlement signed on 27th of January 2020 between Government of India, Government of Assam, Bodo groups. The Deputy Commissioners of Bodoland Territorial Councils, that is Deputy Commissioners of Kokrajhar, Shillong, Baska and Udalguri, are hereby entrusted with overall monitoring and supervision of the schemes pertaining to the following subjects entrusted with BTC. Well, I'm just posing a question to myself. Are they rewriting the accord and the 6th schedule schemes, my lord? Are they trying to rewrite the whole thing? That means, my lord, it is the Deputy Commissioner who will govern the people of Bodoland territorial areas. This is what you mean by devolution of power? Well, with great respect, my lord, how one can even conceive? On one hand, you proclaim that you are giving autonomy to a group. And this is how you are giving autonomy. Please don't give. Even British government would not have done this, my lord. End of the day, my lord, the member of the councils were elected by the people. Now they will be subservient to this deputy commissioner. That means, my lord, it is like an state administered district of the state of Assam. Is that the purpose? In British days, we used to have, my lord, commissioners. Before we had the legislative assemblies. Only after 1935 Government of India Act, the first election was held. Prior to that, there was no election. So is not such a situation is being rewritten. Now kindly, after the referring to the subjects, deputy commissioners and, my lord, the most unfortunate part is their own people has signed this, my lord. These leaders of the so-called group there, they have not understood it, my lord. It's a pity. They claim to, my lord, represent the people, but they're betraying their own people. The deputy commissioner will be responsible for oversight and supervision for district and subdivisional level officials regarding implementation of various schemes by Government of India, Government of Assam, BTC Authority for the above mentioned subjects. Further, they will prepare an annual action plan and get it approved by Principal Secretary BTC with respect to subjects entrusted above for the purpose of their performance appraisal to be forwarded annually by Personal Department. So, my lord, BTC is in cold storage. So, everything will be done by the Deputy Commissioner. Then why you have that 60-member, 40-member or 60-member council? You don't require. So, the powers of the people's representative will be exercised by Deputy Commissioner. This is how they want to augment the powers and functions of the Bodoland Territorial Council. Then my lord will kindly come to page 201. All along, my lord, there was a department called, my lord, in administrative exigency, state government do have power, my lord, to reorganize a setup. That we are not disputing, my lord. But that reorganization attempt must be consistent with the sixth schedule. While doing so, while attempting a reorganization, my lord, one cannot altogether give a go-by to the, mandate of sixth schedule. That is what is being attempted. Kindly see. In the interest of public service, Governor of Assam is pleased to order creation of a new administrative department, namely Welfare of Bodoland Department with immediate effect. The department will be the nodal department for formulation and implementation of the policies and programs for welfare of all-round development of the people inhabiting in the Bodoland area under the sixth schedule of the Indian Constitution, under the sixth schedule council in the state. Then, my lord, kindly come to 5.2. The department also responsible implementation of tribal sub-plan for the state, annual plan, central and state government funded program in the Bodoland area. Department will look after proper implementation of the acts to enable strengthen the border region to discharge their function efficiently as through policy support. So that means, my lord, this department will do everything. BTC has got no function left. To run, control, monitor schemes, programs implemented in BTR, etc., etc. Now, my lord will kindly come to page 146. Please come to 146. 146. Now, what was given to the council by this OM, now it has been taken away. That is augmentation. Now, I have read it once, my lord. By this office memorandum, pursuant to the second MOS or the second Bodo agreement, as we commonly refer, entire power is given to the council. Now, in the name of augmenting the powers of the council, my lord, what they have done, they have entrusted the entire function upon the deputy commissioners and the, my lord, that department called Welfare of Bodoland Territorial Department. Altogether ignoring the existence of an people's elected council, as of that is a 40-member, now disregarding their, and unfortunately, my lord, their own leaders have signed this act. Now, my lord, why we are before your lordships? Please come to page 203. My lord, when we approached the Honorable Supreme Court by your filing as Article 32 petition, the Honorable Supreme Court verbally said, my lord, that they would like to have the views of the High Court in the matter. In other words, Honorable Supreme Court was of the view that let High Court decide the matter first, then we'll have the advantage of having the High Court speak. That kindly see, my lord. Page 203. The writ petition is dismissed as withdrawn with aforesaid liberty. Needless to say that the petitioner are at liberty to approach this court if the need arises. Lordship knows, normally Honorable Supreme Court, my lord, when it reserves the liberty, then only we can go again. Otherwise, my lord, without this line, we can't go. That's the practice. That's the convention. It is only when liberty is given, then again, supposing lordships do not accept our contention, then in that case, we can again go. But if this line is not there, we can't go. In other words, this Honorable Supreme Court wanted to know the view of the High Court on the issue. Because Honorable Supreme Court felt that High Court being in, my lord, in the close proximity of the scheme of things, would be in a better position to appreciate. Now, my lord, this is the case in nutshell. What we are trying to project for a lordship's kind consideration is, Bodos are undoubtedly, my lord, one of the group who inhabited this statement. They were one of the, my lord, oldest group. Going from present BTR, then North Assam and all these places is entirely dominated by them. Even this Guwahati city, my lord, if you go to the interior areas, you will find it is all surrounded by Boros, Garos, Karbis, Ravats. So therefore, my lord, they had a legitimate demand that we should be ruled by ourselves. Why we should be ruled by Assamites? And this was a demand which was rightly accepted by the government of India and which resulted in that first accord, followed by second. And now, my lord, this third has come in the name of augmenting. They're trying to take away everything. So this is the factual background. Now, when it comes to, my lord, legal challenge, my submission would be, these are some of the powers which has been constitutionally conferred. A power which has been constitutionally conferred, being a constituent provision, can it be tinkered with by an executive fiat? This notification at page 201 and, my lord, 199, this cannot withstand judicial scrutiny, my lord, apart from anything else. This 199 and 201, these are utterly perverse. It is the constituent exercise of constituent power, my lord. The constitution was amended, whereby provisions were incorporated for creation of an autonomous, district. Now, can the state, by some bilateral or trilateral arrangement, tinker with those provisions? These are the legal issues which arises for consideration. In nutshell, this is my submission. I'll only have to elaborate. So what I propose to do, subject to what your lordships may say, in nutshell, this is my argument. Let them say whatever they would like to say. To that, I'll reply with some case laws. That is what I propose to do, subject to what your lordships may say. Now, my lord, the law has changed. There was a time when it was felt by the Honorable Supreme Court that when a challenge is laid to any legislative action, then very limited grounds were available. Now even manifest arbitrariness is one of the grounds which has been evolved by the Supreme Court. Is this not manifest arbitrariness? Right from, my lord, Naftes, constitutional morality, then, my lord, Naftes, then Putuswamy. These are Saira Banu. Then, my lord, Nargis Mirza. Then, my lord, 2018 10 SCC. No, it Naftis. So in all these judgments, my lord, now the Honorable Supreme Court has said that even manifest arbitrariness is also a ground which can be invoked to interfere with a legislation. In other words, my lord, if I am to articulate my arguments, it's a fraud on the exercise of power by the state. It's a fraud, my lord. It's not that they are not aware of the consequence, they are aware, but they have done it. So therefore, time is there, it is time has come, my lord, they should be told that you are wrong. You can't do like this. Because you are playing with the emotion of the people. On one hand, you are trying to portray that you are giving autonomy to a section of people. In the name of autonomy, you want these deputy commissioners and this commission to take decisions? Then what for you need this council? If everything, what money will be spent, how it will be spent, if they decide, then why do you, in that case, my lord, we don't need this legislative wing of the state also. The executive wing is good enough. Why people often say president rule is bad? That's the reason. It's something like you are imposing 356. When you take away the right of an elected people's representative and entrust the administration unto a two governor and two advisors, that is a situation which we call president's rule. Is it not a president rule like situation? Therefore, my humble submission is, my lord, this so-called devolution of power has been truncated in a manner that it goes to the root of it. It can't be envisaged, it can't be countenanced. Now, that is how I propose to deal with subject to what your lordships may say, my.
Yes.
I did to the Lordship, for the respondent of affidavit, the contentions raised by my senior primarily would relate to the state government. One, two things which I would like to point out before your lordship. So far as the MOS at page 155 petition is concerned, lordship will see that a commission has to be appointed. The commission will look into those subjects which are given in paragraph 3, page 155. And thereafter it will make its recommendation, lordship. That report is yet to come.
What report?
Commissions. If I am, it's yet to come. Therefore, at this point of time, I do not think lordship will venture into that. It's something which is yet to come. We do not know what would be the findings of the commission. It may give a positive finding, it may not give a positive finding. My lord, for the benefit of my learned friend, let me explain that, my lord. We are not on the report of we are saying the constitution itself is without authority. But if tomorrow report comes, we'll see. But for the present, we say you don't have the authority to constitute that commission. Because you are going, eating into the very concept of that sixth schedule, area. There's nothing like that. But since my friend was referring to it, so far as a department for the BTC is concerned, Lordship, that is envisaged in the settlement itself, Lordship, that if I may take your Lordship to my affidavit, page 8. No, we are not. No. That's-
Respondent one.
Yes, Lordship. And so far as the powers, in my humble submission, vested upon the deputy commissioners is concerned, Lordship knows well that the elected bodies, the legislators, they do not act by themselves. They have to act through the executive, Lordship, but they are answerable to the elected members, Lordship. Therefore, the powers vested upon the deputy commissioner and the ultimate analysis, Lordship, they will be answerable to the elected members of the council. Lordship, my submission will be, I do not see any, Lordship, lacuna or any defect in the functioning of the state. Because whatever power has to be exercised through the executive. They are answerable to the legislature. That is another aspect of the matter. Thank you. And Lordship, my Lordship submission will be, Lordship, minimum submissions would be that, Lordship. 3 accords were signed, Lordship. There were representatives. And so far as the devolution of the subject is concerned, that is already done. But however, Lordship, the notifications issued by the state government, Lordship, perhaps the state would be in a better position to explain that. But from my end, Lordship, I would submit, Lordship, I would reiterate rather, Lordship, that the action that has to be, the executive action that has to be taken has to be through the executive, Lordship. But in the ultimate analysis, Lordship, they are answerable to the elected members. So the elected members by themselves cannot come and exercise because they are not the persons on the field, Lordship. So far as the notifications are concerned, Lordship, I think the state will perhaps throw some light on that.
State.
Number 8.
My lord, insofar as the BTC is concerned, my lord, respondent number 8. We are the beneficiaries, not the main stakeholder, my lord. The state government of Assam and the central government being the signatories of the accord, my lord. I think it would be proper since the constitutionality and legality of the accord has been put to challenge, my lord. I think the state will be the proper person to address your lordship on this issue, my lord. So far as BTC is concerned, my lord, so far as the statement made in paragraph 7 is concerned.
Okay, then we'll hear the state first. Where's the advocate general? When do you want?
My lord, can we expect tomorrow, my lord, because my friend has come from Delhi for this case.
The AG would be coming for some other case tomorrow to address lordship.
In my case, he will give the reply.
So since he'd be here, then maybe he can also reply in this so that we can have a.
But Kian Chowdhury, the next council, assisted by Mr. Council for the petition.
Yeah, case.
Also heard Mr. Al-Kidib Chowdhury, learned Deputy Solicitor General of India for respondent number 1. Mr. Asarava, learned Standing Counsel BTC for the respondent number
8, my lord.
8. On request made on behalf of Mr. D. Saikia, learned Advocate General Assam. List the matter again. If remarks the 10th
For further hearing, my lord.
of February.
Well, can I take little liberty in respect of item 21, my lord? After 10th of February, my lord.
On request made by K.N. Chowdhury, learned Senior Counsel for the petition. For the appellant. When do you want? After
After 10th of February, any date convenient to lordship.
Okay, 15th?
Well.
February.
Deep, sir.
Item 19.
Yeah, your lordship. But in this case, I am appearing in person, my lord. But this is a very peculiar case, my lord, in which, my lord, the electric supply of my office premises, my lord, which I have in Guwahati when I was practicing law here in Guwahati High Court, my lord, was disconnected during the peak Corona period in August 2020. And when we approached them, they said that we had to, I had certain bills to be paid, which I paid, including the reconnection charges. Still, they did not reconnect, saying that the meter has been removed. I have to apply afresh. I did everything possible to avoid litigation, my lord, but I have been compelled to approach the Honorable Court. The learned single judge, instead of directing reinstatement and the consequential benefits, the learned single judge directed them to refund the money that they have received for reconnection, and with liberty to us to file for fresh connection, which is, and my case is that this is a case in which they have violated not only the Electricity Act, provisions of Electricity Act for disconnection, but their own regulation. Their own regulation, my lord. They have violated their own regulations, my lord. I have prepared a my lord, list of dates and the low points, my lord, which kindly have a look, my lord. And the low points and the rules which they have violated. Yes, please take it.
Both parties are here?
It's only two, my lord, two of us.
I'm representing all the respondent.
My lord, this is very, my lord, I just may I take it. But they did not issue any orders for disconnection, my lord. Though the learned single judge directed them to produce the records to show that some decision has been taken as to why it was disconnected, why they did not produce so, my lord. And it was, your lordship, may I take your lordship to
My lord, may I just submit it? My lord, the APDCL have got standing instruction. We are ready to give him connections, fresh connection, if he gives us the proper documents and everything.
Well,
But-
I'm not on that. My friend,
My lord-
my case is that it has been, they have illegally disconnected. So therefore, I'm not only entitled to reconnection, for which they have taken even money, fees, reconnection fees, but I'm also
My lord,
entitled to.
absolutely wrong, my lord. My lord,
Let
learned
me
single.
complete my case, my lord. I don't know why,
No.
why is it, whether, my lord, my case is that everybody, every citizen has got a right to get the fresh connection. What liberty is required for that, my lord? Anybody can apply for fresh connection. My case is that it has been disconnected illegally. So therefore, I'm entitled to the consequential reliefs, the compensation and damages and the loss that I have incurred for the last 4 years because of the illegal disconnection. My lord, your lordship, may I kindly see, may I take your lordship to the relevant portion of the rules, my lord, which they have cited in their counter affidavit, my lord. Page number 23 of my list of dates. My lord, I've annexed the enclosed the relevant portion, my lord. Page 23, my lord. This is the Assam Electricity Regulatory Commission, ordered by the governor, my lord. Number 1, general. Well, got it, my lord?
These regulations shall be called Assam Electricity Regulatory Commission's Electricity Code Regulation 2017. So here after called as Supply Code. These regulations come into force from the date of their publication. So it was published, my lord, on 18 November 17. So then, my lord, your lordship, go to the next page, my lord. Temporary disconnection, my lord. The supply may be disconnected temporarily in following cases. Disconnection due to non-payment of bill amount. This is my case, my lord. It was during Corona when the whole nation was under lockdown. Lockdown, my lord, they disconnected. When the whole nation was under August, my lord, 2020. When the whole nation was under lockdown and they disconnected. And you will also kindly see this is very important, my lord, 8.2.1. Where a person neglects to pay any charge for electricity or any other sum due from him to a licensee by the due date mentioned in the bill in respect of supply, transmission, or distribution or wheeling of electricity to him, the licensee may, after, well, this is very important, Lord. The licensee may, after giving not less than 15 clear days notice in writing to such person and without prejudice to his rights to recover such charges, cut off supply of electricity until such charge or sum together with any expenses incurred by him is cutting and of the recurring supply are paid but no longer. Well, after giving not less than 15 days clear notice, which then not even a single notice was served to us, admittedly, in their counter affidavit, they are saying that the notice that contained in the bill is suffice, is the disconnection notice. Well, may I take your lordship to the notice which they are referring, my lord?
Forget that other file.
Affidavit there of affidavit taken, page number 70 of the memo of appeal, my lord, page number 70. This was filed on behalf of all the respondents. My lord, I take your lordship to page 73, my lord. Page 73 of the memo of appeal, my lord. Memo of appeal, my lord, not the list of dates, not the list that I have surveyed. My lord, it is pertinent to mention herein that the temporary connection of the petitioner premises was done as per 821 of the AERC. This is the one which I just read out, my lord. 821 of ARC, where it is clearly stated that 15 days notice is to be given before temporary disconnection. In the instant case, the notices issued to the petitioner were duly served as the electricity bill itself contained the notice under section 56(1) of the Indian Electricity Act 2003. Therefore, the 15 days notice as per 821 of the Electricity Act was duly complied. Well, Lord, now, my lord, your lordship, may I let us go to the rule they are referring to, the electricity bill notice which they are referring to, my lord. Page number 76, my lord. Page 76, 77. Section A1, my lord, for their counter. My lord, this bill contains, my lord, my lord, disconnection notice may kindly be said, my lord.
Where?
In the page 77, my lord. Their notice, 77, page 77. There is a notice point, disconnection notice. Under section 56 of under section 56(1) of the Electricity Act 2003, power supply to your premises will be disconnected at any time due to non-payment of arrears amount if ignored, if already paid. Now, this is a notice. First of all, this cannot be a notice because notice has to be served as per the rules of their own regulation and also Electricity Act, section 171 of the Electricity Act. Here they say, my lord, it shall be disconnected if it is under section 56(1) of Electricity Act, my lord. Because this notice, even if it is taken to be a notice, my lord, even if it is presumed to be a notice, it is a notice under section 56(1) of the Electricity Act, not their regulation. Whereas their counter affidavit as page number 73, my lord, says that it is pertinent to mention herein that the temporary connection of the petitioner premises was done as per 821 of the Assam Electricity Regulatory Commission, my lord. This is what they're saying, my lord. They say that this was disconnected as per 821 of the regulation. Whereas this notice, even if it is presumed to be a notice, it is a notice under section 56(1) of the Electricity Act. And then, my lord, again, even if it is presumed to be a disconnection notice, even if it is presumed to be disconnection notice, then in that case, my lord, the procedure which is provided in their regulation, my lord, may be kindly looked into, my lord. The procedure, my lord. May I take your lordship to the relevant portion? I have reproduced all the relevant portion, my lord. Page number 28. Page number 28, my lord, of the list of debt, my lord, of the return argument. Return argument, my lord. This here I have reproduced all the relevant rules, my lord, regulation. My lord, 10.3 service of notice, your lordship. Any order, notice, document to the consumer by the distribution licensee, including the notice under section 56 of the Act, shall be deemed to be duly served if it is. My lord, it is very important, my lord, your lordship may kindly say, including the notice under section 56 of the Act, that is the Electricity Act, is to be served in the following manner. Sent by registered post, it was not done. Sent by speed post, not done. Courier at the correct postal address, not done. Delivered through the special messenger, not done, my lord. Then if a consumer refuses, my lord, B. If a consumer refuses to receive or avoids receiving the notice, or if there is no person to whom the same can be reasonably diligent to be delivered, the service may be effected, affixing the notice at a conspicuous place on the premises of the consumer, which shall be deemed as sufficient for service of notice. Yeah, I'm reading. Why I don't understand. My lord, I don't understand why, my lord, this kind of submission my friend has been interfering. A notice may also be delivered by any of the following means: fax, email, or SMS. They've never sent it. Have you sent any notice under fax or email to us? Any? They are simply saying, my lord, they cannot say something which they have not said in their affidavit. Now they are simply saying, my lord, in their affidavit, in their affidavit, they have said, my lord, that again, I'll keep on reading, my lord, if, with your lordship's permission, that it is pertinent to mention herein that the temporary connection of the petitioner premises was done as per I-21 of the Assam Electricity Regulatory Commission Code, my lord, 2017. This is what they said. And it is disconnected as per this. And they never said that they have issued any notice to us. What they're saying is that the notice contained in the electricity bill is sufficient notice under this regulation. How can this notice be sufficient? First of all, it is under section 56(1) of the Electricity Act. And now let us see the 56(1) of the Electricity Act, my lord. Electricity Act. As it is, as they have referred it, so it is important to see the said provision also. Electricity Act 2003. The Electricity Act 2003. May I take your lordship to section 56, my lord? 56. 56. Disconnection of supply in default of payment. This is their case. Where any person neglects to pay any charge for electricity or any sum other than a charge for electricity due from him to a licensee or the generating company in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice. 15 clear days notice, my lord. This is again very important, my lord. 15 clear days notice in writing, my lord. Clear days notice in writing to such person and without prejudice to his right to recover the such charges or other sum by suit, cut off supply of electricity, and for that purpose cut or disconnect any electricity supply line or other works being the property of such licensee or generating company through which electricity may have been supplied, transmitted, distributed, or wheeled, and may discontinue the supply until the such charge or other sum together with any expenses incurred by him is cutting off. So here also 56 says clear 15 days notice in writing, which admittedly they did not do. They're simply saying that the notice contained in the electricity bill suffice. And now again, my lord, this also doesn't, let us, my lord, this notice says the Act as well as their regulations, my lord. My lord, the Act as well as their own regulation says that 15 clear notice should be given, is required to be given. But now let us go back to the notice that is contained in the electricity bill, my lord. It is saying power supply. will be disconnected at any time. At any time, my lord. Where is the 15 days notice, my lord? At any time, there even it is presumed to be a notice. The provision of the regulation as well as the provision of the Electricity Act both says that it should be 15 days clear notice, my lord. But this notice in the electricity bill says at any time it will be disconnected. At any time. So how can it suffice? Then again, my lord, section 171, this section 56, notice is to be served as per section 171, my lord. I take your lordship to section 171 of the Act, my lord, Electricity Act. Service of notice. 171, 171, my lord, of the Electricity Act. I'm referring to this Electricity Act just because they have referred the notice. Otherwise, their own regulation is enough, my lord, will suffice the whole purpose. Your lordship may kindly say, service of notice, orders or documents. Every notice, order or documents by or under this act required or authorized to be addressed to any person may be served to him by delivering the same after obtaining signed acknowledgement receipt thereof. They've never delivered it to me, my lord. Where is the question? Let them produce any sign, signature that they have delivered it. They have not said. They're saying that the notice contained in the electricity bill is enough notice. Then, my lord, let us come back to their own regulation again. How much, my lord, illegalities they have committed? Their own regulation, my lord. My lord, disconnection page 24 again, my lord. My lord, they are supposed to intimate within, my lord, immediately. Just wait. They're intimate 1 year. Notice of service of notice. It's going to wait. My lord, page 26, the licensee sale. Page 26 of the written argument, my lord. The written argument. The licensee sale. The licensee sale intimate the consumer, my lord. The licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of the disconnection. Well, this requires that it should be disconnection should be intimated to us within 24 hours of disconnection. They never did it. They never did it. But my lord, in their counter affidavit, they never did it. But at the time of motion hearing and in the counter affidavit, they submitted a form 18. This format 18. They filed the format 18 in their counter affidavit saying that they have done it. Now, in that regard, my lord, I take your lordship to their notice. Page number 85 of the memo of appeal, my lord. Page 85. My lord, they are saying that they have served the notice which is stipulated in the licensee shall intimate the consumer in case of temporary disconnection in the format 18 of this code within 24 hours of disconnection. Now, my lord, I take your lordship to page 85 of the memo of appeal, my lord. This is the document, my lord, which they never submitted to us, but they filed in the affidavit, counter affidavit, and at the time of motion hearing. Now, I take your lordship to the date, right top date of this so-called notice intimation, format 18. My lord, it is 16/11/21. My lord, 16/11/21. Then let us go to the back to the, my lord, here, as per their own information, my lord. This is to inform you that your supply has been temporarily disconnected with effect from 28/2020. 28/2020. A thing which is to be required to be done within 24 hours, they have done it after 15 months. If at all they have done it, which they never did it. Let them produce any document saying that they have intimated to us. Even if it is presumed that they have done it, they did it after 15 months, which is to be done within 24 hours, my lord. And they never did it, my lord. This is only in the counter affidavit in the motion hearing time they produced this document. They never issued to us. Then again, my lord, the rule again, my lord, thereafter they did permanent disconnection. And under section 56 of the act, there is no permanent disconnection or temporary disconnection. There is only disconnection. But their regulation says permanent disconnection. When temporary disconnection, after temporary disconnection, permanent disconnection can be done. Now here, my lord, permanent disconnection is page number 26 of the my list of date, my lord, my written argument. Permanent disconnection. The supply shall be disconnected permanently in following cases. On the termination of the agreement, my lord, this is on the termination of the agreement. This is what they said. If the cause for which the supply is temporarily disconnected is not removed within the notice period, they never issued any notice to us to say that it will be permanently disconnected. So therefore, the question of the removing doesn't arise. My lord, on the termination of agreement, a termination of agreement in this regard again, my lord, the rule says. Then again, my lord, page 27 shall be deemed to be terminated on expiry of 15 days or after expiry of the initial period of agreement, whichever is later, without prejudice to the rights of the licensee or the consumer under the act for recovery of any amount due under the agreement. After termination of all agreement, the licensee shall intimate the consumer in format 20 of this act. They have never done it. Till now, they have not done it. They have never informed us. And let them say whether they have done it. Neither they have filed their affidavit to this effect, or neither they have informed me in any, as far as 24 hours information, my lord, they have never done it. But they said they did it. Let us presume that they have done it, but they have done it after 15 months, not 24 hours, which they never did. And here, this after permanent disconnection, which is to be done, intimated to us in under format 20, they have never done it. Neither they have stated anything about it in their affidavit, or they have admitted or denied. You will see this format 20, I reproduced in my note, my lord. You will also may kindly see this format 20 is page 34. Page 34 of the my written argument, my lord. This is the format which they are supposed to intimate to us, which they have never done, not till date. Format 20. And now, my lord, they have this is a case as per their affidavit of disconnection under their own regulation, and their own regulation require 15 days clear notice in writing, which they have never done. And in their affidavit, they have said that the notice contained in the electric bill itself is sufficient to prove that notice has been served. Now, my lord, in that case also, I would like to say that they served. I had received, my lord, so many. I have annexed it. My lord, can you see? They kept on this notice, my lord. If at all it was a notice, which was valid notice, my lord. My lord, may kindly see from page number 77 of my memo of appeal. As per their affidavit, my lord, it was disconnected in August 2020, and they kept on issuing this notice, this electricity bill with the notice, even 4 or 5 times thereafter. Now, 4 or 5 after disconnection, which is the question of notice saying that it will be disconnected. They did it after 4 or 5 times thereafter, my lord. Your lordship, may kindly see as per their affidavit, they disconnected on, my lord. I was just reading it, page number 85, on 28/2020. Well, 28/2020 was their intimation. That's what they say after 15 months. And thereafter, my lord, let us see the bills 77, page 77 onward. This is a bill of 1/6/2020. Okay, this is okay, my lord, because this was before the disconnection. Then next one is 1/7/2020. This also before the disconnection. Then 13/8/2020. This also 13/8/22. This is also before disconnection. And then, my lord, thereafter, all the disconnection notices, my lord, you lordship may kindly see all thereafter
6, 7 of them, page 81 onwards, my lord. 80, 81, 82 till 84. They issued the bill which contained the so-called notice of disconnection. What is the question of this notice, my lord? If they said that this is a notice, then why did they kept on servicing this notice that it will be disconnected, it will be disconnected? They've already disconnected. There is a question of disconnection, it will be disconnected. So this, the document which contained in the notice, so-called notice, it is contained in the, it is a mere formality which contained in every, and it has been held that this such notices cannot be a valid notice because the notice has to be served as per their own regulation, how notices to be served, and how, as per the Electricity Act, it has to be affixed in the wall if I refuse to accept it, affixed in the wall. But they are saying that this is the notice. They have, and signature as per the Act, signature is necessary, my lord. They are bound to take our signature of service of notice, page section 171, my lord. Or if I refuse, they can affix it. Again, my lord, 171, registered post, obtaining signed acknowledgement received, therefore, or by registered post. Let them produce any receipt, page number, section 171, my lord. No, I'm not completed, my friend. Please.
One minute. What were you submitting?
Yeah, my lord, the entire plea that he has taken, my lord, that has been dealt by the learned single judge.
Yes, that's why I challenge, under challenge. He wants to justify, my lord. At the time of initiation of this appeal also, he was justifying like that this has been dealt by the learned single judge. So no, it is no more, I cannot, I'm not right. I cannot, this appeal is not maintainable because it has been dealt by the single judge. That's why I'm before the division bench. I'm before the division bench. How can he take the shelter under single judge's findings? This is what he has been doing, my lord, right from the beginning. The single judge judgment is under challenge. Single judge says that you file your, my lord, I even, in order to avoid litigation, my lord, being a senior advocate, my lord, I knew that the disconnection is illegal. I still, my lord, I paid whatever they demanded. And within the time, last date of the time, my lord, I paid reconnection charge also, who is the learned single judge directed to refund 600 rupees. This is the learned single judge says that the REIT is being partly allowed by directing them to refund the reconnection charges which they received from me. My lord, I was not supposed to make any payment. I was not supposed to make any reconnection charge because the disconnection itself is illegal. So once it is illegal, the consequential relief would follow, my lord, as per the law that I'm going to cite, my lord. A number of judgments, my lord, I've recited. Now, my lord, the first of all, my lord, it is to be seen whether the temporary disconnection is as per the rule, as per their own regulation, because there is no provision for temporary disconnection in the Electricity Act, and which is contained in the notice. Notice says under section 56, it will be disconnected anytime, whereas the section 56, as well as their own regulation, says that 15 clear days notice is to be given in writing, and the so-called notice contained in the bill says at any time, so that 15 days is gone. Then it is under section 56, and their disconnection is under their own regulation. That is what they said. And if they say that it is under section 56, then 56 doesn't have any temporary disconnection. There is only one connection, that is disconnection. So if they want to go for temporary disconnection, they can go only under the regulation which they have done. So, but nothing has been followed. The notice has not been served. The 24 hours intimation has not been made. Never been made, my lord. It was not done even up till date, but only they produce it in the affidavit or at the time of motion hearing, my lord. And even if I admit, I presume that it was served to me. Then it was served after 15 months, which is not valid. Void ab initio, right from, because it has to be served within 24 hours. It is clearly stated therein. As far as permanent disconnection, no time is given, my lord. It has to be intimated. So at least till now, they have not done it. That permanent disconnection, they have not done it. Then, my lord, they want to justify their action by bringing in so many things. Mahinder Singh Gill says, my lord, I came this morning, my lord. I have I requested my friends to give the notice that citation, but I have reproduced everything in my note, my lord. Note.
See,
Yeah.
Abu, if I'm not wrong, the council was saying that they're ready to connect your.
No, my lord, they're saying that I have, that is right from the beginning they are saying, my lord, but I'm not on that. They're saying that I have to apply a phrase. Why should I apply a phrase, my lord?
Correct.
Yes.
My lord, what has happened actually is that from the first day when this motion matter had come for motion matter, he had got an interim order also that you apply fresh.
Where is
and
the
they're
interim
gonna
order?
give-
Where is the interim order? Can you show me? I've got the order. Please don't give false. My lord, right from the beginning, he's been misguiding the court. My lord, he has been given liberty by the court on 2 occasions. I've annexed it, saying that, my lord, my list of date, written argument, my lord, written argument. It is here, page number 21 of my written argument. Please see. Page 21 of my written arguments.
Please, I'm not giving a false statement. You please submit.
Right from the beginning, he's been giving false statement, my lord. What is the liberty? Court says that if at all I apply,
My lord, at page 52, my lord, of the
paper,
appeal, my lord.
paper book.
This is the first day the matter was moved in motion, my lord.
Page
52,
of the appeal memo.
appeal memo.
Order dated 27/4/22.
Yes, my lord. At page 53,
Oh,
petitioner shall serve requisite copy thereafter in the event of any application filed by the petitioner for fresh electricity connection. After such disconnection of electricity in his premise at so and so, shall forthwith give necessary supply electricity to the said premises of the petitioner on payment of requisite amount if so required. However, it is made clear that any such payment made by the petitioner for such fresh connection of electricity in his premises, Guwahati made to respondent APDCL shall be subject to the outcome of this writ petition.
Yes, where is the liberty? If at all I apply, I don't apply, I won't apply because they have disconnected illegally. So the consequential relief follows, my lord. Once it is held that the disconnection is illegal. Now, why should I apply? The court never said that you apply. Court said in case you apply, it will be subject to the writ petition. Whereas the court gave them liberty on 2 occasions to reconnect. Page number 22 of my written argument, my lord. Written argument. On 2 occasions, which they did not honor. This is 22 order was to the reason as to why it was disconnected, my lord. Sir, Mrs. Sharma, learned counsel praised for an adjournment to produce the records of the case in original, which may contain the decision and the reason thereof as to why the electricity connection of the petitioner was disconnected. They never produced it, my lord.
My lord, that is absolutely, my lord. May I just submit here, my lord?
Why this is not a debate, my lord, my friend. I'm really surprised. We are not on debate. See, my lord, liberty was granted to them, not to me. Liberty was granted to me, not to, my lord, to them, not to me. Page number 35, my lord. Page 35. 36 is the relevant portion of my written argument, my lord. Written argument. Last sentence of page 36, my lord. Pendency of this writ petition shall not be a bar for the respondents to restore the electricity connection of the premises of the petitioner. Then, again, my lord. Again, page 38, my lord. One more order, my lord. 38. Page 38. In the meanwhile, it is made clear that pendency of the writ petition shall not be a bar for the respondents to consider the prayer of the petitioner for reconnection of electricity supply to his apartment. This is, my lord. And my lord, your lordship, one very strange thing is that, my lord, I knowing it well that their demand for my reconnection or the payment of the bill, etc., is illegal. I did make the payment, my lord, thinking that why should I take such kind of your lordship, may kindly see, their demand was at page number 45, my lord, A1. And I did make the payment immediately thereafter, my lord, page 46. The last date, your lordship, may kindly see page 45 of the memo appeal, my lord. Bill period from right side may be seen, my lord. Due date 29 May, my lord. 29 March 22. 29 March 22. And on 29 March 22, next page, my lord, I made the entire payment, my lord, page number 46, annexure A2, including the reconnection charge, which was not required to be. I knew that it is illegal. I am paying illegally claimed amount. It was not required to be paid. Because their disconnection was illegal, so therefore I'm not supposed to make them a reconnection charge. I'm not supposed to pay. But still I paid. I paid so to avoid litigation. and other problem. Then, my lord, they did not do it. Then reconnection charge, my lord, page number 47. Page number 47 is reconnection charge which I paid. Then, my lord, they did not do it. Still, then I submitted this legal notice to them. Page number 48. That I have paid everything done. I have done everything, but you are not reconnecting. Then, my lord, they did not do it. Then I sent one of my junior from here, my lord, colleagues, Usha Das. She went to their office to requesting them to reconnect. They did not do it. Then I had to file the writ petition, my lord. And now, my lord, my question is, I was always ready to, my lord, to even I paid the amount, I paid the reconnection charge, though knowing it very well that it was illegally disconnected. But still, in order to avoid litigation, I did it. But still, they did not reconnect. Therefore, I filed the writ petition. Now, my lord, in this regard, my lord, the Supreme Court has said, my lord. Now, Supreme Court, I take your lordship to the Supreme Court, my lord. My written argument, my lord, judgments. My lord, in the Mahendra Singh Gill's case, the Supreme Court said, Mahendra Singh Gill's a very landmark judgment, page 5, my lord, I have referred herein. Means, my lord, the respondent, Supreme Court, Mahendra Singh Gill says that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order made in the beginning may, by the time it comes to the court on account of challenge, gets validated by the additional grounds later brought out. So they have to bank on the order which they have, my lord. Then, my lord, again. Then, my lord, I take your lordship. Now, my next judgment would be, my lord. My lord, State of Odisha, page number 15, my lord, I've given. State of Odisha and another versus Mamata Mohanty reported in 2011 3 SSC. Para 37, the judgment of this honorable court has held that it is a settled legal proposition that if an order is bad in its inception, it does not get sanctified at a later stage. A subsequent action development cannot validate an action which was not lawful in its inception. If an order at the initial stage is bad in law, then all further proceedings consequent thereto will be non-asked and have to be necessarily set aside. Their first action is temporary disconnection. It is illegal, my lord. If your lordship holds that is illegal, all further permanent disconnection, these that are meaningless. Because Supreme Court says that the inception, it has to be seen in the first inception. Then, my lord, again, they say, my lord, that we cannot reconnect because your meter has been removed. Your meter has been removed. In that regard, my lord, how they are saying their meter has been removed. In the bill, my lord, which is at page number 45, itself says that, your lordship, page number 45 of the memo of appeal, my lord. Right, fifth line from the right top, my lord. Annexure A1. My lord, your lordship may kindly see bill date 14 March 22, number of days 42. Then, my lord, meter status, there is a provision called meter status, my lord. Running. It says meter status running. But they have submitted before the honorable court, my lord, which is a Annexure A1 judgment reported by the your lordship, page number 52. The judgment, the order of this passed at the time of motion hearing. It has been recorded by the honorable learned single judge. What they said, but due to non-payment of dues in spite of notice issued to the petitioner, the concerned meter in the residence of the petitioner at Orient Place, Guwahati was removed prior to the payment of the bill. So before I paid the bill, they removed the meter, they said. And whereas the meter, this reading meter, the bill itself says that status of the meter is running. Then again, my lord, let us presume that they say that, okay, they have removed it. But it is their mistake, my lord, because last date is yet to be done. And they removed it. And in this regard, my lord, the Honorable Supreme Court, page number 16, my lord, of my written argument, in Bharatiya Seva Samaj Trust versus Yogesh Bhai Ambalal Patel, reported in 2012 9 SCC 313, here the Supreme Court says, my lord, that a person alleging his own infamy, page 60, A person alleging his own infamy cannot be heard at any forum. What to talk of any court? If a party has committed a wrong, he cannot be permitted to take advantage the benefits of his own wrong. So now they have removed it. Though they are saying that it is running, and now they are saying that we have removed, so therefore we cannot reconnect it. Then, my lord, again, even if it is presumed that it was legally disconnected, everything was right, my lord. Even in that case, the Supreme Court has held that, my lord, in Assistant Engineer Ajmer Bidyut, this is the electricity department, my lord. Ajmer Bidyut Vitran Nigam Limited and others versus Rahmatullah, in paragraph 6.4, it says that, my lord, the disconnection cannot continue after the amounts are paid, which I paid, my lord, which I paid, though I was not supposed to pay. I paid, my lord, page number 46. Page 46. Who is the London Single Judge directed to refund the reconnection charge? And, my lord, when, my lord, as far as the their own regulation saying that they should give 15 days notice, clear notice in writing, and then their own regulation says that how notice is to be served, they have not followed it. Now, in this case, my lord, Babu Varghese and others versus Bar Council of Kerala and others, as reported in 1999 3 SEC 422, page number 18, my lord, of my written argument. It says that, my lord, this is a basic principle of law that long settled that if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. It was just argued some in the earlier case also, my lord, by my friend, my senior friend. So, my lord, my case is that, my lord, they are, as per their own affidavit, they could not justify, they could not produce any document to say that they have served notice. And it is not only a natural justice. Natural justice, the principle of natural justice says that notice should be served. In some cases, it is held that these are all useless formalities by Supreme Court. But here in this case, this is not a natural justice. It is a statutory requirement, both in the Act, Electricity Act, as well as in their own regulation, my lord, in their own regulation. Statutory requirement which they have not fulfilled, my lord. They have not followed. So therefore, I'm entitled to not only the reconnection, my lord, but also the loss that have been incurred, my lord. I had rented the place, getting at that 5 years back 30,000 per month, my lord. I have annexed the lease agreement also that I'm entitled to, my lord, as apart from compensation. And the whole building has been, my premises has been damaged. Water supply pipe has burst out, and everything, my lord, has been because of. So they are liable to compensate me for that, my lord. That's my case, my lord. Because admittedly, my lord.
So that would be before the civil court.
But it can be, my lord. It can be. Any order can be passed by the court, my lord.
Cannot pass such an order. You have to approach the civil court.
My lord, but my lord, this connection may kindly be, your lordship may kindly give the finding as to whether it is legal or illegal, my lord, because they have totally violated their own statutory, their own regulations. Leave aside Electricity Act.
Lordship may submit. My lord, the entire issue, my lord. First of all, my lord, this is the AIRC Supply Code of 2017, and this is the Mother Act is Indian Electricity Act. So, as per my lord, the findings, the same argument what my learned single friend has dealt with, it was done before the single judge also, my lord. And my lord may, that's why I'm referring to the judgment itself. My lord may come to page 104. Relevant provision of the Electricity Supply Code, my lord, at the bottom. And then, on wide notification dated 6/11/2017, AERC Supply Code was made in exercise of the power conferred on Section 50 and Clause 10 of Subsection 181. It came into the effect so and so. So that's how we adopted the AERC code, my lord. Thereafter, my lord, may see under Regulation 1.3.2, reference has been made to the related provision of the Electricity Act, Section 50, amongst others, relating to recovery of electricity charges, intervals of billing, and disconnection of for non-payment of charges, restoration. Section 56, relating to disconnection of supply in default of payment. So Section 56 and Section 8.2.3, what my learned senior has been talking about is the same thing. Section 56 talks about the Mother Act, and after we adopted it, 8.2.3 comes in effect. So we give a reflection of section 56 or section 8.2.3. It makes the same application, my lord. My lord, thereafter, my lord, he argued at the end that the meter bill has been running. It is not that, my lord. It was the contents of the energy bill is provided in regulation 6.3.a, which includes among other the status of the meter, whether the meter was okay, whether the meter was defective. That is what the status of the bill deprecates. My lord, now there are two bills. The one bill which was served upon him was a PDC bill. That is the permanent disconnection bill. And the bill before that, which I have annexed in my affidavit, are the bill which are the normal bills that are given to the normal consumers. In that bill, my lord, he has said that the 15 days period has not been mentioned. My lord, I would like to take you to that bill. Even this issue has also been dealt by the single judge. Where I'm my lord, at page 83. '83, '84 are all the electricity bills, my lord, from page 77. My lord may see under section 56(1), third column under the bottom, under section 56(1) of the IE Act, power supplied to your premises will be disconnected at any time due to non-payment of area amount ignored if already paid. And at the top, my lord, the bill date, may I see, 12/8/2021, and the due date is 27/8/2021. Exactly 15 days. 12/8/2021 to 27/8/2021. It is exactly 15 days, my lord. My lord, all the bills from 77 till 84, the same notice is there, not only in the case of the petitioner, but every consumer of the Assam Power Distribution Corporation Limited. The same bill is sent that you have to be paying your bill within 15 days, or otherwise under section 51, your connection will be disconnected. Now, my lord, he did not choose to pay the amount. Now, after he did not choose to pay the amount, my lord, we gave him a temporary disconnection. My lord, I would like to refer to the court, my lord.
Let's wind up.
Is it?
Getting boring.
His entire argument is that we did an illegal disconnection. We never did an illegal disconnection. We proceeded as per the law and as per the code. That is why the learned single judge, while hearing the matter, took into all the provision to check whether there was any illegality, and he did not find any illegality.
We'll
My
take up some other day.
Yes, my lord.
Sahu, when are you coming?
Well, I can produce my video, my lord, any day. Lordship can, my lord, video conference if I cannot come, my lord, any day in the next week or convenient your lordship, my lord.
Not BB Sahu, then petition in person.
Appellant in person.
Appellant in person. Also heard Mr.
SP Sharma.
SP Sharma, the standing counsel.
APDC.
APTC. Is this matter on? I'll give you a date.
My lord.
30.
30, my lord.
Yes.
My lord, 30. I have a case. So let it be on 1st, my lord. I may come out. 1st of February, my lord.
1st February.
I look like.
My lord, my lord, can it be on 6th? My lord, this Tuesday when it's a hearing day. On 1st, my lord, there's a reopening of the Shillong bench. There's difficulty on me on that.
No, I'm because of Shillong. I have a case on 30th in Shillong, my lord. And 31 is the holiday. We're having
6.
No, I'll not be able to come because let it be or before 29. No problem, my lord. 29, I can come here and then go to Shillong.
29th.
January.
Huh?
29 January.
No,
That is not the hearing date.
I can go on that. 29, my lord, no problem.
28 is Sunday.
29 or 1st, my lord. 29 or 1st February. So you can take it 1st February.
First, I have a matter.
Then 29, no problem.
29th.
I look like.
Item 20.
Lordship, this is a case Lordship has hard,
May I please, your
substantially, your Lordship.
Lordship, I appear for Education Department, my lord, on the last occasion, original record was thought. My lord, we need some more time, my lord.
No, we are not keeping part third. We don't know whether the bench will continue or not. Okay, head Dr. Sharma and the council for the.
Lordship, on the earlier occasion, Lordship wanted to have a look at the rules existing at the relevant point of time. That I have brought here, Lordship, that may be kept on record, your Lordship.
You introduce it the next day. MS
Okay, that's.
Kedas, the standing council.
Lordship,
Elementary
would it come on
Elementary
12th
education.
this month?
List the matter again on when?
12th.
My lord, we need some more time, my
How
lord.
much?
After 2 days.
24th. To enable her to produce the reports.
But
Lordship.